May I please your lordship? I beg to make sure. One I 5071 of 2024 for early here.
When? Next Monday.
Please, your lordship. Your lordship, I beg to mention for an IA, your lordship, in RSA for condemnation of plea, your lordship. The other party has appeared, your lordship. IA for condemnation of
Tomorrow. Next
Next.
Monday.
may I beg for listing RSA. RSA
For what?
for hearing, my lord.
Take the advice of your other friend who has mentioned it. The first one. Take the advice what it. Mr. Samaria, yesterday's matter, that probate matter, I'm again keeping it for tomorrow. There's some more hearing required in that matter.
Issue, my lord, pertain to hearing on what? So that we will
137.
My lord?
137.
The detailed explanation of what? We'll get
137. In fact, after dictating, as I was seeing the order and also checking out the judgment of Justice M.R. Shah, some more clarifications is required in respect to
No,
137.
the
In
second
fact,
aspect is also, I
as
think,
to whether it was at all required for filing the condonation application, that is the issue.
now, lordship, second aspect is also very important to, I think, lordship may like to answer that the time to, my lord, counsel, therefore, lordship, one line there has been facts and circumstances. But it's an exceptional situation. But normal nomenclature is that it should be counted from the date of the testator, my lord. Normally, my lord. Because this citation.
No. If you see M.R. Shah's judgment, it doesn't say so. That is the problem which has happened. You see, the earlier judgment of 1998, that other, with starting with the K.
Yeah.
That judgment says, quotes paragraph 16, 15 and 16 of the judgment of the Bombay High Court,
Right.
and says that we don't agree to what has been stated in paragraph B.
Right.
But it's not so clear.
Well, that's why, well, what happened, I have gone for so many citations that which is the actual position that it is be counted from the date of the test, either or the fact of circumstances. Now, on these diversions, findings are coming. If lordship clarify the position in two counts, that first that normally it should be counted from the date of test subject to lordship clarification, or in exceptional set the facts and circumstances to be clarified, because lordship in a lordship that should I have referred judgment sufficient was thereafter lordship expanded the wing by saying that it should also be dispensed to be exercised in the right direction.
No, sufficient. The question does not arise. No.
Verify this position. I think it will helpful to all of us.
Yes, no. Why I am saying it, section article 137, if it is applicable,
Yes.
then the question arises when the right to apply accrues.
Exactly, madam. Exactly.
Now, in the case of arbitration matters, it says the right to apply accrues when there is a dispute.
That's understood judgment.
Yes. So, from the date a dispute accrues, the right to apply accrues.
Yes.
Whereas, in this case, when the right to accrues is not clear, taking into account that a person has a right in respect of a probate to exercise his right when it is necessary that his right is infringed, for which he may require. Sometimes it may be a case.
Right.
That is why I mentioned it in my order
Exactly.
yesterday also, one aspect to the matter, that if in a circumstance that a particular property is given to somebody, he is exercising, but his right is now being infringed, for which his right to accrue, he may not allow, he may like to go for a probate. So that is on the basis of which, but there is one, not that judgment, but there is another judgment you see on this article 137, There's another judgment, but it's a lengthy judgment, not this judgment of
My-
Justice Chandrasur.
Not that.
There's another judgment of where it has been more elaborately described.
get
Yes,
I will-
today in the morning I was just looking through it. I couldn't get it.
I will find it.
You just find out on that. Huh? Tell Mr. D.K. Kolite about this.
Fine.
He's there, na, underside?
Yes.
I'm having it tomorrow.
Fine.
You make a mention for an upgrading.
Fine.
The matter will take you up immediately after the motions.
Fine.
Or motion and admission.
But 2 p.m. might be better because he will also come that point of time. I will inform him. I will try to inform the other side counsel also.
Not today.
Not tomorrow. I will inform
tomorrow.
the other side
It
counsel.
will come up in the list.
Yes, but I
So-
will also otherwise inform him that this
Yes,
case will
yes.
be.
Where are these people? Yes.
Senior counsel Saibala is on deck in another court.
Huh?
Senior counsel Mr. Saibala is on deck in another court.
Don't worry, you argue the matter. Why there are 2 appeals?
With regard to
Yes, you answer.
My lord, there were 2 suits, my lord, which were tried together. One suit was filed by the appellant, my lord. The other suit was filed by me. Now, both these suits were tried together and a common judgment was passed.
So it's something like a counterclaim.
It is something like a counterclaim. Basically, they say that, my lord, their case is that a sale deed in my favor, which was executed by their uncle, is bad because a specific portion was sold to me. They say his uncle could not have sold it to me without a partition. Then I have filed another suit where I say that this was already partitioned and this particular portion was already handed over to me along with the house, and I was subsequently dispossessed, which is why I filed the subsequent suit for recovery.
Declaration and yeah, in
Regard.
respect to that same port.
Yes, in respect.
So they are challenging the deed.
Yes.
They are seeking a declaration.
That the deed is bad.
No, not only that, for their right title interest
Yes,
Yes.
yes.
and also for confirmation of possession.
Yes.
So you have on the other hand sought for declaration of your right title interest and recovery of
Recovery.
possession, which was allowed.
Yes.
Now the principles out here would be section 44 of the transfer of property.
That's
Is-
the substantial question of law. form.
That is. Now why they are saying that whether section 44 would apply? That is the substantive question.
That is the
Why?
substantial question. They perhaps want to rely on the proviso to contend that the subject of
dwelling house-
request was a dwelling house of an undivided family.
It was a dwelling house.
It was initially used as a dwelling house, and my case is that I was handed over possession and then I was subsequently dispossessed
Of the entire house.
of the entire.
Whether they had a title on that.
No. There was already a revenue partition whereby they were given the northern part. The contest is basically in the southern part where there is a house and now perhaps that sawmill is not existing anymore. There's a sawmill that
There's no dwelling house.
there was an Assam type house which was used for dwelling purposes, but our case is that the uncle actually the uncle says that I purchased it by myself out of affection. I had incorporated his name in respect of one particular sale deed, which is 4 kothas of land. Then I say, then the uncle says that the nephew was allowed to stay there as permissive occupier. And thereafter, my lord, there was a part, since he wanted a share in the land, since his name was there was a revenue partition and he was allotted the northern portion. Thereafter, my lord, the uncle purchased another 5 lechas on the extreme south. So he was granted a separate patta for the southern portion measuring 2 kotha 5 lechas.
So the patta was issued.
Yes, there was
In
a
your
revenue
answer.
partition.
So after revenue partition, that particular
The
plot of
portion
land,
was sold to.
a separate patta was issued.
Yes, yes.
And there is no challenge.
There
to
was a challenge paid.
Then what remains?
That is
How is 44 or any other thing applied? Yes, man. Huh? Can't help it. The 2004 matter. let me dictate the judgment. By the time it finishes, you get ready with your substantial question of law argument.
No, now the position is such, my lord. They say the uncle had 2 kathas of land, but he could not have sold the southern portion. Now, ultimately, since the filing of the suit, they're in fact now in possession of the entire 4 katha land.
Who?
They. Because the uncle left, he sold it to me and he left. I was given 2 katha, 5 lakhs on the southern part. They dispossessed me, that is of course subject to proof, but now the position is, their case is southern portion could not have been granted without a partition, and he did not have a right to select the southern portion. But at the end of the day, now they are in possession of the entire 4 katha 5 lakhs.
How much was sold to you?
2 katha 5 lakhs.
That is what where the separate patta was issued.
Yes. Yes. Southern portion, there was a revenue partition.
So you have a separate patta.
I have
for
a
that.
separate patta.
No, did the uncle have a separate patta?
The uncle
Had a separate patta.
uncle had
Now,
a separate.
if there is a challenge
Yeah.
to the state,
Revenue partition.
to the revenue partition or the issuance of a separate patta, have
My
they
lord,
challenged it?
separate patta, my lord, the revenue board order is there. Patta is not the problem. Difficulty is, my lord, half the records could not be traced out.
It's okay. But whether the patta was put to challenge,
No. The patta was not put to challenge, but I must clarify the patta was not exhibited. It was the revenue board order against that order of partition.
but did you get a patta?
That I have to check the record, but patta is not, the patta document, patta is not there.
No,
In my-
it will be seen from the documents which have been exhibited.
Alright.
From whatever it is, it isn't mentioned in the last page of the.
No, it is not mentioned in the last page. New
It's a
patta now,
very,
dark and
very
patta
old
numbers were
matter.
carved out, my lord.
It's a very old matter.
Yes. My lord, it was held up because the records could not be traced, and eventually it was decided that an attempt would be made for hearing. Even we don't have the entire record, my lord.
Because seeing the person who were the appellants then,
Yes.
the lawyer,
Yes.
I know he used to be my father's senior.
My lord,
This must be from Dibrugarh.
yes.
Yeah.
My client has turned 90, my lord, and they have appellant has died.
And they have
So they
subsidy.
have been
Your client is Shiva Prasad Datta.
Yes.
And their client is,
Sons of Sulakshan Singh, Pyara Singh,
Pyara Singh,
Kripal.
no, who died?
Kripal, Pyara Singh.
Pyara Singh died. Kirpal Singh alive?
No, he's a
Tara Singh?
Surjinder Singh and Harjinder.
And how does the first appellate court hold about the partition?
My lord has which appeal? 132.
132?
At page
Suit was
23.
decided separately.
My lord?
Suits were decided separately.
No.
Common judgment.
Common.
But why there is a one judgment on title to appeal or this is appeal? Appeal, they have filed one.
They filed two.
242/81 and 32/78.
Yes.
32/78 is by them.
Is by them. It has been referred to as suit X.
And the other one is 40. By
Now, how does let's see what are the issues saying.
Issues your lordship finds at page 11.
Page 44. Whether there is any cause of action, whether the suit is maintainable in law, whether the suit is barred under 154, whether the defendant wants own purchase the land measuring 5 acres from defendant number 3. If so, whether the sale who is the defendant number 2? Defendant number 1, Tara Singh. Now, Tara Singh is an appellant here.
What?
Huh? You are appealing for Tara Singh?
Pyara
Pyara.
Pyara.
Okay.
Pyara is son of Sulakshan.
Now, defendant number 1 is Tara Singh.
Yes.
Tara Singh is the brother of Sulakshan Singh.
He's an uncle.
Ishwar Singh, Bhagat Singh.
He's
They
the
are uncle.
uncle. Tara is the uncle of Sulakshan.
Is the uncle of Sulakshan? No.
Yes.
Or
Yes.
cousin?
Yes, no, uncle.
Okay. So Tara sold it to defendant number 2.
Yes.
And also purchased land measuring 5 acres from defendant number 3. Now, defendant number 3 has no business.
Defendant number 3 is done.
So 5 acres is out.
5 lakh is there. My lord,
How is 5 acres involved? Because if it is being purchased from defendant number 3,
yes.
what right do they have as regards the 5 acres?
5 lakh they have no right.
No.
But they now have said that it was procured from joint family fund, though his name was not recorded. Therefore, he has a.
Whether the plaintiff has right, title and interest over the suit land and the house. The debate for non-subsistence is dependent. Now, where is the second suit? What are the issues? Again, issues are whether the defendant number 1
11.
is the absolute owner and whether the plaintiff has acquired any right, title and interest. So 5 letters was issue number 4 in
Yeah, issue
Yes.
number 4
in suit X, that is his their suit.
Yes.
Now, have you seen the recent judgment of the Supreme Court in Rambalak? That day I was referring in one matter. There was a case, this is of this Bihar. They had a consolidation authority who has the right of a civil court in respect to those matters which are barred from the civil court. Something like more like a revenue authority. That the Supreme Court categorically observes a very significant aspect of the matter. Say that though a revenue authority, revenue entries are not documents of title, but then also when those authorities, revenue authorities or the consolidation authority, exercises power which is akin to the civil court on the basis of their title, and those things have to be respected. Now, in this case, when the revenue authority out here have already decided that there is a partition, once that partition has happened, then where is the question of anything else? You see this judgment,
I found it, my lord. Is it 2024 SC7 SCC online 725?
yes. I show you. Balakram or something,
Yeah.
But-
Ram Balaksi.
This is a very pertinent judgment because here one very important aspect of the matter is a partition has already been held and that has already attained. Now, in view of 144, the civil court cannot enter here. If the civil court can't enter into that aspect of the matter and it has attained finality, can the civil court now say, or this court now come up and say that this portion of the land which have been partitioned out,
It's still an undivided.
Section 44 or anything applies? When it comes to this paragraph,
Para 15 onward, probably. Para 15, 16. Yeah.
Paragraph 16.
16.
Under the scheme of the Consolidation Act, the consolidation authorities are fully competent to deal with the issue of title over the land under the consolidation except under certain contingencies. Thus, the consolidation authorities have the power of the civil court to decide the question of title subject to judicial review by the High Court under 32, 22, 226 and 227 of the Constitution. In other words, the consolidation authorities have the status of a deemed court and has the power akin to the civil court to decide the rights and title of the parties over the land under the consolidation. We are not consolidated. Kindly come to 17.
We are conscious.
We are conscious of the fact that revenue entries are not documents of title and do not ordinarily confer or extinguish title in the land, but nonetheless, whether revenue authorities or the consolidated are competent to determine the rights of the parties by exercising the powers akin to the Code of Civil Court, any order or entry made by such authority which attains finality has to be respected and given effect to. Now, in view of this proposition of law, this having attained finality by the order being passed by the Board of Revenue that there is a partition, and this is the land which has been sold to you,
Yes.
how will 44 come in? Isn't that the answer?
That's precisely the point. Because and it had withstood the challenge of an appeal also.
They filed an appeal, but they went to the Board of Revenue also.
Did not go further.
So under such circumstances, what remains? How
And-
will 44 will come in?
And the
44 will only come in because here, if the civil court is permitted to touch. Now, did they challenge that revenue partition in the High Court, civil court?
in the civil court they made a prayer.
The prayer you can't do, isn't it barred?
Yes, it's barred under 154(8). Claims regarding perfect part.
And how did the courts take note of whether 154 was a challenge out there? But they didn't challenge it later on.
Yeah.
You see, this
No,
is
the
about
trial court gave a reasoning.
no, trial court's judgment here at here,
Page
page
58,
55.
55.
This issue is related to the provisions of 154. In Suit Act, the main contention of the defendant is that suit is barred under section 154. Now, on going to the provision, it reveals that taking of cognizance by a civil court is barred on the facts concerning the validity of settlement, amount of revenue tax, so and so, so and so, so and so. But where the complicated questions relating to title are involved, or where the plaintiff seeks declaration of his title over the land, which is the subject matter of a suit, the civil court has jurisdiction to entertain the suit and adjudicate the matter in controversy.
Now, again at page 58, if you look at please.
Yeah.
Page 58 from the top color.
From the unchallenged and unwritten testimony period,
Top of the page color.
that I've seen it.
He said this
The former defendant became the absolute owner of his share of land measuring 2 kathas. This defendant number 1 failed to prove that there was any family settlement after the revenue part.
Yeah.
But as only land was partitioned to the aforesaid revenue partition, and there was no partition regarding construction standing thereof, either amicably or through court, the construction on the entire land measuring 4 kathas 5 letters remains joint because PW1 in the suit act by oral and documentary evidence. Exhibit 21 proves that the engine of the sawmill was purchased by his father, Sulakshan Singh, and the same was installed on the suit land, and by exhibit proved that the business carried on by his father and Naya was joint. Business is different. That does not have any relation with the land.
and the house is on the southern portion. If the revenue partition in respect of the land is also held to be good, my lord, then in that particular land the houses are. So there cannot be a separate partition of the structures and the land underneath it.
Read page 58 from the unchallenged and unrebutted testimony
of PW3 and PW4 in suit X. It can safely be said that remaining 5 letters was also used by the defendant number 1 and pro forma defendant in suit Y prior to purchase of it. That apart, the oral evidence as well as the documentary evidence, exhibit 20, 21 and 22 in suit X, it can be presumed that the land measuring 4 kathas purchased by in the year 1951 and the constructions thereon, including constructions on 5 letters of land, were made from the joint fund of the defendant number 1 and pro forma defendant Tara Singh. The pro forma defendant alone had no right to dispose of the construction along with the land to the plaintiff by exhibit 3 in suit Y, as there was no proper partition of the construction standing on the suit.
Now, tell me, where is the finding that there is where is the observation that there is a dwelling house? What is the evidence as regards the dwelling house?
Dwelling house, Malod, they say they are in possession.
Possession is different.
Yes.
You have to understand a dwelling house under 44 is a different aspect of the matter.
Of an undivided family.
Undivided family, so other people can't, you can't transfer it.
Yes.
Where is the dwelling house aspect?
There, Stanley or Doctor will find in the other appeal.
No, no, appeal, forget about the appeal. I'm not on that. I'm only on the judgment.
Trial
on
judgment
the
wala-
pleading.
Trial judgment wala this.
For me, second appeal records are not too much. Yes. Here in this suit, their suit, let us see where they have said in their first suit that there is a dwelling house.
The descriptions of the structures are at page 69 of the other.
Who is the defendant number 4 in this suit? Plaintiff.
Defendant number suit in title 42 is the
No. Who is defendant number 4?
Tara
Tara Singh.
Singh.
Tara.
Tara.
Finally comes to paragraph 6, page 69. Owned a truck and he applied the same for the hire and he took some construction work there. This is your suit. This is your suit, huh?
Yes. Yes.
Paragraph
mine.
6.
Should I
He
read it?
kept the truck with nothing. Where is the plaint of the other suit? They raised the issue, no? The
Page
learned counsel
63.
could respond to contended that section 44. Between the respondent and the suit asking where is this plaint?
66 of
In the second suit, no?
RSA 130.
60?
Six.
And dwelling house, in terms with section 44 would mean what? A family residing.
An undivided family residing. That with the
But they were not a part of the family.
they were not.
Let's see. Do you have any any judicial pronouncement on that?
No, my lord. Well, what I was going to argue is this: 44 would have application if a share of an undivided dwelling house is given. Now here, no share has been transferred. To me, the whole of the house is transferred to me. If your lordship simply provide the
Hey, transfer.
because otherwise, my lord, there are of course judgments which have said
See, the basis why it is being paid is so that the joint family is not disturbed. Yes,
I'm
very well. I'm just waiting to dictate the judgment. I told your junior, let me start the first person, and then at the time when the substantial question of law comes, Mr. Sahawala would be very much present.
Joint family property only, my lord. That is joint family property.
How?
they purchase the land, in this Kolkata. Then
No. Let us first come to purchase later on. How is joint family property?
the joint purchase.
No. Jointly purchase is a joint owner.
Right.
Joint family is different. Don't bring the concept of family. How they related. That if they were to remain as a family. You see, that is what I was asking him. The concept of dwelling house which is being brought in, it says that normally a co-owner can very well, he is just a co-owner. Co-owner can very well sell it. He's part of it. But the legislature thought that in a family where family is residing, you can't bring in an outsider. And therefore this proviso has been brought in. Unless you say that you were a joint family, that is why I put you. Unless you say that you are a joint family, how do you bring in the proviso? That is the most pertinent. Secondly, already there is a revenue partition done. Rightly, wrongly, it has happened, it has ended, and it is closed.
That is being challenged in the that is being challenged.
You can't challenge in the suit. Once it is being done, how does 44 come into the picture?
Yes.
You did not challenge. You could have very well challenged it under 226.
Five the land the subject matter. That was in fact included in the patta of the original owner later on, and it was purchased by both of them.
That was purchased joint.
Although it-
You in your plaint itself said that yes, it was purchased by in the name of by the defendant number 4, or by the defendant number 1. He purchased it in his name, but I also it is from the joint income. That is it. But the trial court said nothing to that effect, that they could not prove it. That is not the substantial question of law before this court. The substantial question of law is one, that is as to whether 44 would apply or with section 3 and 4 of the Partition Act. First of all, normally a co-owner can very well sell it. But if it is a family dwelling house, then you can't sell. But did you prove that you are a part of the family to come within the proviso? One. Secondly, it has already attained finality as regards the partition, which has not been challenged in accordance. You can't file it by a suit because a perfect partition cannot be challenged under 154. No, if you have not challenged and the partition has already happened, then how does 44 come into the picture? You may have a right over the house if you have made, you may be entitled to whatever may be. That may be a different aspect to the matter. But you don't have any right over the land. And for that you to prove that you have constructed out there, you have made any special, you made certain investment out there, that is nothing is there which has been proved. And that is not the substantial question.
Sawmill is established, I purchased the
Sawmill, now, if it is a sawmill, where is the dwelling house?
along with the dwelling house.
Now, you see, if it is only a dwelling house, the question is different. But you can bring in a sawmill. The concept of dwelling house is a person where a joint family is residing and you can't break it by bringing in Mr. Deka out there. You can't bring in a family where Mr. Sahewala and his brothers are staying out there. At last, matter hence. And the appeal was done. I was just saying it is a very old matter, taking into account that the suit was drafted by my father's senior. Late Indra Sama, he did it. When we used to be this small, he used to come to our house. This is at that point of time. The suit was drafted and it was ended into it. At last it finishes in my hand. Till it goes to the Supreme Court.
I don't think.
Okay. heard Mr. G. N. Sahabala, the learned senior counsel, assisted by Mr. P. Bhattacharjee. K. Bhatt-
My lord, may I?
Yes, yes.
Again, my lord, I have to put my-
No, it's okay. No, only that. I just wanted
my
to
lord, sure.
give you an opportunity. I wanted to dictate because I keep on dictating earlier and the last portion is
My lord,
only.
I-
And Mr. B. D. Decker, the learned counsel, appearing. Respondents. Both the appeals are taken up together, taking into account that the RSA number 133 133 oblique 2024 arises out of a proceeding being title suit number 7832 oblique 1978
Got to 133 of
2004 arises out of title suit number 32 oblique 1978 and RSA number 132 oblique 2004 arises out of title suit number 42 oblique 1981. From a perusal of the materials on record, it reveals that the title suit number 32 oblique 1978 that the title suit number 42 oblique 1981 is a cross suit to title suit number 32 oblique 1978. It is in view of the similarity of the facts and the issues involved. Both the learned trial court as well as the learned first appellate court have taken up both the suits as well as the appeals filed there against together. And this court, therefore, would like, therefore, take up both the second appeals together for disposal. An interesting thing, do you know, Mr. There is no substantial question of law framed here in 133.
133 no.
There is no substantial issue notice.
I think there's
Same question of.
same question of law on 13/8/2004.
From a perusal of the order dated 13/8/2004, passed in both the second appeal, it transpires that only in transpires that in both the second appeal, the same substantial question of law have been formulated. Which A as under. For deciding as to whether the two substantial questions of law so formulated in the present two appeal are involved in the instant appeal are involved. This court finds it relevant to take note of the brief facts which have led to the filing of both the appeals. Title suit number 32/1978 was filed by one Tulakhan Singh.
Sulakhan.
Where is the S? Sulakhan. I don't know whether the court made a mistake or something. The predecessor in interest of the present appellants. In the said suit, it was the case of the plaintiff therein that the said plaintiff, along with the defendant number one, Tara Singh, is dead. Since deceased, had purchased a plot of land measuring 4 kathas in dark number 458, covered by periodic patta number 250/274 of South Amlapati, Dibrugarh, which was specifically described in Schedule 1 of title suit number 32/1978. The said suit, in the said suit, it was also mentioned that in the said dark, there was an additional area of 5 lechas which belonged to one Hori Prasanna Das. It was further alleged that the plaintiff and the defendant number 1 in the said suit carried on the business together and out of this joint family, out of their joint income, the remaining 5 lechas of land, which originally belonged to Hari Prasanna Das, was purchased from his son after his death, one Hiranya Kumar Das. Hari Prasanna Das. It was alleged that both the plaintiff and the defendant number 1 jointly constructed a house over the said land, which was described in Schedule 1 to the plaintiff. And both the plaintiff as well as the defendant number 1 used to reside sometime in the year 1975. The defendant number 2 in the said suit, who is the respondent herein in the present appeals, wanted to take over the possession of the Schedule 1 land forcibly, for which proceedings under 107 of the CRPC was initiated. And subsequently, those proceedings which was, however, dismissed, was initiated by the defendant number 2, which was, however, dismissed. It was also mentioned that prior thereto, the defendant number 1 had filed a revenue partition case number 22 of 1971-72 before the additional deputy commissioner, Dibrugarh, for perfect partition of his share of the land, claiming his share to be 2 katha 5 lechas out of 4 katha 5 lechas covered by Dag number 458/21 of the periodic patta number 250 corresponding to new Dag number 134 and new patta number 21 situated at Amalapati ward, Dibrugarh town, Moza, Dibrugarh. It was alleged that the plaintiff did not get any notice in respect to the said revenue partition case, though notice was received by the son of the plaintiff, however, though notice was not received by the plaintiff. It was further mentioned that the defendant number 1 on 15/5/1973 managed to obtain an ex parte order for partition of the said land, which the plaintiff came to learn from his son, one Piara Singh, bracket since deceased, he also died, who was served with the notice dated 31/10/1974 from the Sub-Deputy Collector, Dibrugarh, East Circle, informing that the land would be demarcated by the town Latmandal on 2/11/1974. A challenge was made before the learned additional deputy commissioner to the said revenue partition order, and on the basis of the said challenge, the revenue partition order date was set aside by an order dated 19/3/75. However, subsequently, when the defendant number 1 moved an application before the same additional deputy commissioner, Dibrugarh, an order dated 5/8/1975 was passed. Thereby setting aside the order dated 19/3/75. An appeal thereagainst was filed before the learned Assam Board of Revenue, By the plaintiff, however, the same was rejected by an order dated 19/7/1976. At this stage, it may be apposite herein to mention that there was no further challenge to the revenue partition order after the rejection of the appeal of the plaintiff by the order dated 1976, and accordingly the order dated 15/5/1973 had attained finally. Be it as it may, the plaintiff further contended that the sale deed which was executed in favor of the defendant number one by the defendant number one in favor of the defendant number two, being sale deed dated 8/8/1975, bearing deed registered deed number 3124 of 1975, whereby 2 kathas 5 lechas of land was sold under Dag number 134/143 of periodic patta number 21/68 of Amlapati Ward, Dibrugarh, Town Moza, District Dibrugarh. The said sale deed also included a dwelling house and a sawmill. It was therefore stated that as the land, that upon the land there was a dwelling house of the joint family in property, the transfer could not be made by the defendant number one in favor of the defendant number two. Under such circumstances, the plaintiff therefore challenged the deed of sale which was executed by the defendant number one in favor of the defendant number two, semicolon, had also sought for a declaration that the defendant number plaintiff and the defendant number one were the joint owners of the schedule of the 5 lechas of land which was specifically described in Schedule 2 of the claim, and further also seeking a declaration that the revenue partition case, that on the basis of the revenue partition case, the defendant number one did not acquire any right to a specific property for any transfer to be made in favor of the defendant number two. In addition to that, it was also sought for, in addition to that, there was also a declaration sought for that the defendant number one had no right, title, and interest in any part of the property described in Schedule 1 and Schedule 2, as he had absolutely made over the same to the plaintiff. The respondent, the defendant number one, had filed a written statement in the said suit. stating inter alia, that the Schedule 1 land was purchased by the defendant number 1 alone out of his earnings, however, the plaintiff's name was included as he was then living with the defendant, and also out of filial affection and to respect the sentiment of the defendant's elder brother, Bhagat Singh, who was then living at Punjab. It was categorically mentioned that the plaintiff never paid any amount for the said purchase. In respect to the 5 lectures of land, which is the Schedule 2 land, it was categorically stated that it was the defendant number 1 who purchased the said land. Further to that, it was mentioned that the plaintiff was only allowed to reside in a part of the house out of filial affection, and he carried on his works independently. It was mentioned that there was no business was ever carried on jointly at any point of time by the defendant number 1 with the plaintiff. It was further stated that out of love and affection, 2 kathas of land, a revenue party out there was some dispute. Why did you go for the revenue partition?
Yes, sir. There was some dispute he started claiming, and therefore we decided to give him.
It was further stated in the written statement that as there was some dispute between the plaintiff and the defendant number 1, a revenue partition proceedings was initiated. And on the basis thereof, a final partition order was passed on 15/5 or 15/3,
15/3/1975.
15/3/1973. And the original patta was split up, and a separate patta being patta number 21/68 of dag number 134/143 in respect of 2 katha 5 lectures was issued in favor of the defendant number 1. It was further stated that the land which was transferred to the defendant number 2 solely belonged to the defendant number 1. after the revenue partition was carried out. And as such, the plaintiff had no right whatsoever in the land which was sold to the defendant number 2. The defendant number 2 also filed a separate written statement wherein the statements made are similar in content to the contents of the written statement filed by the defendant number 1. It was, however, mentioned that the 107 proceedings was initiated at the behest of the plaintiff and not the defendant number 2. It was also denied that the defendant number 2 have initiated the 145 proceedings, as was stated in the plaintiff. On the basis of the said statements and allegations made in their respective pleadings of the parties, the learned trial court framed as many as 7 issues relevant herein to take note of is the issue number 4, which stipulated as to whether the defendant number 1 alone purchased the land measuring 5 letters from the defendant number 3, and if so, whether the sale of the defendant number 1 in favor of the defendant number 2 is valid and operative in law. The issue number 5 stipulated as to whether the plaintiff had right, title, and interest over the suit land and the house. I'm just coming up. As plaintiff instituted the second suit, which was registered and numbered as title suit number 42/81, wherein the plaintiff of the earlier suit was the defendant number 1, and defendant number 1 in the earlier suit was the defendant number 4. In addition to that, the sons of the defendant number 1 in the present suit were arrayed as defendant number 2 and 3. In order to avoid prolixity, this court is not repeating the said averments. However, it is relevant to observe that the case which was set out by the defendant number 2 in the written statement of entitled suit number 32/78 was the case of the plaintiff in the present suit. In this present suit, the plaintiff sought for his right, title, and interest over the land which was described in Schedule A to the plain of the present suit. Which was parameteria in content with the Schedule 3 of the earlier suit, except furthermore detailing given as regards the houses standing thereon. House standing thereon, as well as the sawmill. The defendant, the plaintiff further sought for declaration of his right, title, and interest over the schedule suit premises described in Schedule A, for recovery of possession of the Schedule A. Further to that, the plaintiff also claimed for mean profit by way of compensation, as the details which were given in Schedule B to the plaintiff. The defendant numbers 1, 2, and 3 in the present suit filed a joint written statement, the stand being similar to the stand of the plaintiff in title suit number 32/1978, for which this court is not repeating the contents thereof again. On the basis of the said pleadings, the trial court framed 8 issues in the subsequent suit. And the issue number 4 was as to whether the defendant number 1 was the absolute owner in possession of the suit premises by way of family settlement. And the issue number 5 was whether the plaintiff had acquired any right, title, and interest over the suit premises. Both the suits were taken up were consolidated by the learned trial court. The parties to both the suits adduced their respective evidence, both oral and documentary. The learned trial court dismissed the said suit filed by the suit being title suit number 32 oblique 1978. Whereas the title suit number 42 oblique 81 what trial court gave it again.
Against me. My school was-
The trial court decreed title suit number 32 oblique 1978, but dismissed and dismissed title suit number 42 oblique 81. Being agreed, an appeal was prepared which was registered and numbered as two appeals were prepared. Two appeals were prepared by the respondent herein, which were registered and numbered as title appeal number
1 and 2.
1 oblique 2001 as well as title appeal number 2 oblique 2001. Both the appeals were taken up together and by the judgment, common judgment,
Yes,
Yes.
by a common judgment dated 21/5/2004, the title suit number 32 oblique 78 was dismissed and the title suit number 42 oblique 81 was allowed, thereby granting right title and interest over the suit land measuring 2 kata 5 letters as mentioned in Schedule A of title suit number 42 oblique 81, as well as the construction standing thereon, evicting the respondents, their dependents, removing their goods therefrom with future compensation at the rate of 150 rupees per month from the date of the order judgment passed by the learned First Appellate Court till recovery or possession of the suit premises. Against this, the present two appeals have been filed and in the above perspective, let this court therefore consider the respective submissions made by let this court therefore consider as to whether the two substantial questions of law so formulated by this court by the order dated 13/8/2004 are at all involved in the present appeals. Evidence. This court have heard Mr. G.N. Sahewala, the learned senior counsel, appearing on behalf of the appellant in both the appeals, and Mr. B.D. Decker, the learned counsel, appearing on behalf of the respondents in both the appeals, and have duly considered their respective submissions. What are exhibits 21, 22, 23, and 24?
21 is the intent
Huh?
for the sawmill. That's the intent purchase for the sawmill. And 2020 is the order of card and 24 is the discharge.
Tell me. 21 is
21 is the intent purchase
21
sawmill.
is engine purchase. Purchase voucher.
for the saw mill.
Engine purchase voucher.
Yes, sir.
Huh?
22 and 23 is the order of garden.
22 and 23 is
Order of garden.
order of
The garden. There was a garden.
They're
The
not
tea
on
garden.
record.
security guards.
No, garden, sir.
Order of the garden.
Tea garden.
But they're not available on
They're
record.
not available.
Orders being given to by tea garden for supply of something. Okay. Orders given by the garden. What is exhibit 24?
Discharge certificate.
Discharge certificate. For what? What is your discharge certificate? For what? And how are these relevant to be substantial question of law? Mr. B.D. Dekar,
Alright.
how are these relevant?
Lord, in fact, the appellate court has dealt with it and said that these are no witnesses do not have any knowledge about these documents and therefore they are not relevant.
Whether these, because the question says on the ground that these were tendered in evidence by, were not tendered by in evidence by any witness.
Anyway, that is the finding of the appellate court.
So 67 comes into the picture.
Page-
67?
Page 20, it has been dealt with. 67.
67 will come into the picture.
The
When
issuing
you-
authorities have not been examined. The witnesses during cross-examined admitted that we have no knowledge about these businesses, and it was merely hearsay. That was the finding at page 20
Page 20. Of
of the appellate judge.
which one?
Well, both page 8 and 13.
Same.
Exhibit 20 in the
To
middle.
the joint business of the mark. Plaintiff has produced certain documents marked as exhibit VR to show that the joint business of the plaintiff and but the documents have not been legally proved by examining the witness. So no data no document hold that Lukman has no personal knowledge about the running of the furniture shop by his mother. These two witnesses heard of the joint business of the in respect to the first substantial question of law, as regards whether the learned first appellate court committed error in law in not taking into consideration exhibit 21, 22, 23, and 24 on the ground that these were not tendered in evidence by any witness, this court have duly taken note of the judgment of the learned first appellate court, wherein at internal page number 15, the learned first appellate court duly deals with these exhibits 21, 22, 23, and 24. Full stop. The learned first appellate court, while dealing with these documents, also takes note of the provisions of Section 67 of the Indian Evidence Act 1872, which mandates as to how a document is required to be proved. Full stop. And as such, the learned first appellate court have categorically held that the documents which were exhibited as exhibit 21, 22, 23, and 24 were not legally proved by examining the witnesses. Further to that, the learned first appellate court had also taken note of that these documents, the witnesses who were put on cross-examination also categorically stated that they had no personal knowledge about the running of the furniture shop at Big Boy. And that the engine was purchased in 1952 from Sardar Sarani Singh and Dilip Singh. It was mentioned that they had heard about the joint business and the joint family. This court further is of the opinion that this substantial question of law so formulated cannot be a substantial question of law involving the instant appeal for the simple reason that any decision made in the said as regards the said question of law so formulated would not change the course of the litigation. Under such circumstances, in the opinion of this court, the first substantial question of law is not involved in the instant appeal. The second substantial question of law pertains to as to whether the provisions of Section 44 of the Transfer of Property Act 1882 and Section 3 and 4 of the Partition Act 1893 are applicable in the instant case, and whether the learned First Appellate Court erred in law in not considering the appellant's case in the light of the above provisions. For the purpose of deciding the same, this court finds it relevant to take note of Section 44 of the Transfer of Property Act 1882. The said section is quoted hereunder. For a perusal of the said section, it reveals that where one of two or more co-owners of an immovable property who is legally competent in that behalf, transfers their share, his or her share of such property or any interest therein, the transferee acquires as to such share or interest, and so far as is necessary to give effect to the transfer, the transferor's right to joint possession or other common or part enjoyment of the property, and to enforce a partition of the same, but subject to the conditions and liabilities affecting at the date of transfer the share or interest so transferred. Therefore, the said provision empowers or a owner who is otherwise legally competent to transfer his share of such property or interest therein. And the transferee would acquire the right of the transferor co-owner to joint possession or other common or part enjoyment of the property. However, there is an exception to the said provision, which is given in the proviso, which is given in the second part of Section 44, whereby a transferee of the share of a dwelling house belonging to an undivided family, being not a member of the family, comma, the transferee the first part of section 44 would not entitle him to a joint possession or other common or part enjoyment of the house. Therefore, section 44, the second part of section 44 does not in any manner debar a co-owner who is otherwise legally competent to transfer his right or interest in respect to a joint property wherein there is a dwelling house, but if such transfer is being made, the transferee would not be entitled to the possession, joint possession, or other common or part enjoyment of the dwelling house. There is no bar to that.
No.
The transfer will be okay, but he would not be
Joint
entitled to possession. Full stop. The Supreme Court, in the case of Dora Hawaji Warden versus Omi Sorab Warden and others, reported in 1992 SCC 117. At the occasion of dealing with this section 44 of the Agote Act of 1882, of the Act of 1882, and more particularly to the second para of the said section. It was observed that in order to effect the second paragraph of section 44, the subject matter of the transfer has to be a dwelling house belonging to an undivided family, and the transfer is a share in the same to a person who is not a member of the family. It was further observed that in order to satisfy the first ingredient of clear existence of the right and its infringement, the plaintiff will have to show a probable cause that the suit property is a dwelling house and it belonged to an undivided family. Or in other words, there is the Supreme Court further observed that the dominant purpose of the second paragraph of section 44 of the Act of 1882 was that if there is any danger of an injury or violation of the corresponding right of other members of the family, and an irreparable harm to the plaintiff and the court's interference is necessary to protect the interest of the family. The Supreme Court further observed The Supreme Court further, taking into account the judgment of the full bench of the Allahabad High Court in the case of Sultan Begum versus Devi Prasad, reported in five ALJ 352. Observe that the words undivided family as used in the section appear to be borrowed from, no, had observed, had taken note of the judgment of the Allahabad full bench of the Allahabad High Court, wherein the issue pertained to as regards section 4 of the Partition Act. It was observed in the judgment of by the full bench of the Allahabad High Court that the words undivided family as used in section 4 of the Partition Act appeared to be borrowed from section 44 of the Transfer of Property Act. The last clause of that section prescribed that where the transferee of a share of a dwelling house belonging to an undivided family is not a member of the family, nothing in this section shall be deemed to entitle him to joint possession or other common or part enjoyment of the dwelling house. It was observed that the said provision of the statute is clearly of general application, and the effect of it is to compel the transferee of a dwelling house belonging to an undivided family who is a stranger to the family to enforce his right in regard to such share by partition. It was further observed that the purpose behind this second paragraph of section 44 was to prevent the transferee of a member of a family who is an outsider from forcing his way into a dwelling house in which other members of his transferor's family have a right to live, and in that and that the words undivided family must be taken to mean undivided qua the dwelling house in question, and to be a family which owns the house but has not divided it. In a subsequent judgment, in the case of H. Vasudeva Pai, dead by LRA versus Kamarun Nisha, reported in 2011 15 SCC 76A, the Supreme Court, while dealing with Section 4 of the Partition Act, which was stated to be paramaterial to Section 44 of the Act of 1882, observe that the proposition stated observed in paragraph number 6 and 7 as hereindunder. This court at this stage also finds it very interesting to take note of another judgment of the Supreme Court in the case of another judgment of the Orissa High Court in the case of Udaynath Sahu versus Ratnakar Bech, wherein it was observed, reported in AIR 1967 Orissa 139, wherein it was observed that if the transferee bracket stranger get into possession of a share in the dwelling house, the possession becomes a joint possession and is illegal. Courts cannot countenance or foster illegal possession. The possession of a defendant transferee in such a case becomes illegal. It is further observed that the plaintiff's co-owners are entitled to get a decree for eviction or even for injunction where the transferee threatens to get possession by force. It is further observed that if there has been a finding that there was a severance of joint status, but no partition by metes and bounds, the defendant would be liable to be evicted from residential house and body under Section 44 of the Transfer of Property Act 1882. In the above perspective, this court further finds it relevant to take note of another judgment of the Orissa High Court in the case of Bhim Singh versus Ratnakar Singh, reported in AIR 1971 Orissa 198. And paragraph 21 of the state judgment, being very pertinent to the issue involved, is reproduced hereunder. Therefore, from the above principles of law as settled by the Supreme Court as well as the High Court, it would be seen that there is no bar in transferring a joint family property by a co-owner who is legally competent to do so. But if it is a property, but if the sale is made in respect to a share of a dwelling house belonging to an undivided family, and the transferee is not a member of the family, or for the matter is a stranger to the family, the transferee would not be entitled to his joint possession or other common or part enjoyment of the house. But for the sake purpose, one needs to find out. But for the purpose of invoking the second para to section 44, the pertinent question which arises is as to whether the selling house belonged to an undivided family. In the instant case, though the provisions of section 44 of the Act of 1882 have been pressed into service, read with section 3 and 4 of the Partition Act 1893, but the Schedule A property, but the property as described in Schedule A to title suit number 41 oblique 81, 82,
81,
42 oblique 81,
42.
81. Have already been partitioned by metes and bounds by way of a revenue partition as far back as on 15/3/1973. For which the defendant number 1, for which late Tara Singh was issued a patta, separate patta. Therefore, this issuance of the separate patta have not been challenged by the predecessor of the appellants herein. What was challenged was the order by which the separate patta was created, was directed to be created. This order, which was put to challenge, was set at rest. This order, which was put to challenge, was not interfered with by the Learned Board of Revenue, inasmuch as the appeal filed by the predecessor of the appellant's hearing was dismissed on 19/7/1976. Now, this order, thereupon, continued this court further takes note of that a grant of a revenue partition, perfect partition, as well as issuance of a separate patta is outside the jurisdiction of the civil courts. In view of section 154 of the Assam Land and Revenue Regulations, 1886. This court at this stage also finds it very pertinent to take note of a recent judgment of the Supreme Court in the case of Ram Balak Singh versus State of Bihar and another, reported in 2024 SCC Online SC 725, wherein the Supreme Court observed that though revenue entries are not documents of title and do not ordinarily confer or extinguish title in land, but nonetheless, when the revenue authorities or the consolidation authorities are competent to determine the rights of the parties by exercising powers akin to the Code of Civil Courts, any order or entry made by such authorities which attains finality has to be respected and given effect to. In view of the said exposition, and taking into account that the regular partition, the revenue partition, have already attained finality as far back as on 19/7/1976, and there being no challenge to the same in accordance with the provisions either under Article 2 to 6 of the Constitution before this court or before the Supreme Court under Article 32. The question of application of Section 44 or Section 4 of the Act of 1882 or Section 3 or 4 of the Partition Act 1893, in the opinion of the court, does not arise, inasmuch as the property which has been specifically described in Schedule A to entitled suit number 42/81 had already been partitioned by metes and bounds. Under such circumstances, the second substantial question of law which have been formulated is not involved in the instant appeal. Consequently, both the appeal stands dismissed with costs quantified at rupees 25,000 each, In addition to that, the respondent herein who shall be entitled to the cost throughout the proceedings.
You.
Okay. Yes, where's your friend?
None was there on the other day also.
None was there.
The confined finding my lord. Both the court there.
Just see whether he has entry of a name as co-owner in a return statement in a stealing case automatically creates title without whether the title is true necessitates that level. None appears on behalf of the appellant on call when the matter has been taken up for hearing. Mr.
DJ Thoika.
DJ Soikia appears on behalf of the respondent, taking into account that this court, taking into account that none has appeared on behalf of the appellant, the appeal stands dismissed for non-prosecution. The LCR be returned in time order if any sensitive.
Alright.
None appears on behalf of the appellant on call. In view of the matter, the sustained appeal stands dismissed for non-prosecution. The LTRP returned it to the trial. In time order any stand take it. Yes, mistake.
Right, Your Honor.
It is a question of law.
Hello?
What is the question of law frame?
No, not frame, my lord, regarding whether a gift deed, possession is, delivery of possession is, the requirement of possession being handed over is a provision under section 149.
Hindu or Muslim?
Ah.
Hindu or Muslim?
Muslim,
It's a oral gift.
a registered gift. Registered gift is 3 bighas, my lord, another 2 bighas by oral deed.
What is the actually the substantial question of law?
But actual substantial phenomenon law is this, my lord. Whether here, whether deed accepted or not, that is not decided.
Like your
Started
your
from
thing is when the deed is a registered gift,
Ah.
the question of whether gift have the possession or the has been handed over or not, that is immaterial. That's your case.
Ah.
In view of 149 of the Mohammedan law does not apply. That's your case. Because the question has not been framed in that manner.
So
If
far.
you have seen the order of 19 to 2020. Hello, we come back.
Yes.
Mr. Sheikh, I will take up this item. There is an item at item number. Then I'll take.
President, but these are next.
Who?
Senior and the petitioner. of President.
Where is your
Take up,
where are the
I will-
plaintiff
hold on.
petitioners?
Yes, these-
Where are the petitioners?
These present, a compound, I will call. I will call.
Call.
I will-
Where is he?
In a compound, I will call.
Okay.
I-
Mr. Bhuya,
Lordship.
earlier they filed an CRP.
In the year 2006,
This CRP was dismissed when?
It was dismissed on Lordship 26/2/2010.
Then they file a review.
Then they filed restoration petition case. And review, Lordship,
Now what happened?
review file earlier.
Then what happened? Restoration
Restoration of the dismissal default.
on
They filed a review petition, Lordship, on 4/1/2006.
Hmm.
And during pendency of the review application, they preferred civil revision on 7.
now the suit has been stayed.
Suit has been stayed
How many years?
since 2006, Lordship.
What is the suit for?
Suit for specific performance of contract. Suit for specific performance of contract.
His suit.
This
His suit.
this suit.
And what was the order? 35, 3011 for?
That is for Thirty 11/2005.
Hmm?
But they filed 3 petitions, Lordship.
Hmm.
One petition to examine 2 witnesses, additional witnesses. That is
Yeah.
one Rohini Barua and Bhagavan Das.
Hmm.
Both are no more. Both are no more as
Hmm.
on date.
Hmm.
Thereafter, another petition was filed for recalling some documents from JMDA. And another document is filed, another petition is filed for recalling the witness, official witness sub-register. So 3 petition was there, and 3 petitions filed. Order dated, Lordship, it is page number 88, Annexure 13.
So this review was filed in 2006.
No, review, Lordship. Review was filed 2006 before this just division number 3. Then the matter was transferred to Munship number 2. During that year, and the review was disposed of on 2013. Filed Annexure 16. Order dated 24/5/2013.
Yes. Where is your person?
In the house.
Huh?
He's on the way.
We asked him to come at 2. We asked the police to immediately arrest him. Where is your senior? Why he doesn't know this matter is fixed at 2? Then he has taken this court for granted. Why? No, this court has specifically fixed this matter at 2. Where is the petitioner? Where is the petitioner, Mr. Counsel? Where is the petitioner? We'll ask the security to bring him. Where is he? Why he has not come when there is a specific order for personal appearance of him? What? I have already given you 10 minutes of time. You have already spoiled 10 minutes of judicial time. You know the expenditure which is being incurred by the government for the purpose of a judge sitting in the court per minute? You have to incur the expenses per minute. We have already crossed 10 minutes. You have to take into account the salary of the judge, the salary of everybody who is there, light, pen, everything, and then we calculate and commensurate what is the cost which will be imposed. Per minute will be something around 1 lakh. What is your name, Mr. Counsel? And Thakuria. Okay, we cancel your bar license till you pay this 7 or 10 lakh rupees.
Okay.
That is your lookout. I'm not bothered with that. Your senior, whoever it is, he was supposed to be here at 2 o'clock, but the matter is fixed. He cannot escape from here. You have not brought him anybody. I'm asking which police station are these people from? Ask him to arrest him and produce him before the court. These 2 police stations. Ask both of them to be arrested and produced before. This court, by an order dated 25/2024. I'm not. I've asked you to. So what? When your license is suspended till you pay this amount, you ask your senior to make the payment. We want. This court, by an order dated 25/2024, directed the listing of the instant matter today at 2 p.m. specifically. Directing one of the petitioners to be present before this court. Neither the earlier counsel who represented the petitioner or the person who or the counsel who filed the petition, Mr. Neither the counsel who represented the petitioner on one Mr. S.J. Sharma, advocate, nor any of the petitioners are present before the court at 2 p.m. This court waited for 10 minutes, then also none has appeared. On the other hand, a counsel, an associate of Mr. S.J. Sharma, appears and submits that some time is required. For what?
For appearance.
At what time? What time? Okay, we have at the 2:30. If they are not appearing, I'm telling you, ask your senior to be present here. We'll see what does he want. And take this court for this court for. Mr. Sheikh, you have a registered gift deed.
Yes.
Now, the question is, there was no delivery of possession.
But not in that deed itself, it is said that
Where is the deed?
deed at PS number 12 of
Who filed the suit?
PS number 12 of 2000. Test, lower court record, my lord, test 35.
No. Who filed the suit?
Suit was filed by one
Moziron Nessa.
For what?
She claimed that he is the niece of Patata.
Hmm?
Niece of Patata.
What of Patadar?
Niece.
Oh.
Patiji.
Lessee.
Niece. 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 Patiji. Nephew niece.
Or niece.
Yes.
Niece of the Patadar.
Yes.
Okay. Then?
So, my lord, family chronology is like this.
Hmm.
One Putrot Khan was there.
Hmm.
We belong to the family, my lord.
Hmm.
Out of Putrot Khan, there was two sons, my lord. One is Tahir Khan. Another is Osman Khan. From Tahir Khan, my lord, 3 sons. And from Osman Khan, 2 sons. We are the descendants of one of the sons, that is
Who are you? Muhammad Sattar.
Muhammad Sattar, my lord, Kansu Khan. We are the descendant of Kansu Khan. Same family, my lord.
The original Patadar was Nayan Ali Khan.
My lord, Joyanuddin.
Huh?
Joyanuddin Khan.
With Mazam Ali.
My lord, Mazam Khan, one of the son of Tahir Khan. Mazam Khan, then
That is
Noyan
not-
Khan, then Joyanuddin Khan. So Mazam Khan have a wife, my lord. Wife died, and thereafter, my lord, Mosdina is from Noyan Khan, plaintiff, and Joinuddin Khan. The land belonged to Joinuddin Khan because Joinuddin Khan got the decree of the land by the good time.
The plaintiff is the daughter of Nayan Ali Khan
Noyan Ali Khan. My lord,
and
just
the niece
1
of
minute, my lord.
late Joinuddin Khan.
My lord, just 1 minute. I have said that Putrot Khan, then Tahir Khan. Tahir Khan, 3 sons, my lord. And one Mazam Khan, Noyan Khan, and another is Joinuddin Khan. So, my lord, Noyan Khan is the father of Moziron Nessa. He is the plaintiff. Now, my lord, what happens? He is claiming the land of Joinuddin Khan. Joinuddin Khan, his uncle. Not from the father. Father, he is not claiming. He is claiming the land of Noyan Uddin Khan.
Joinuddin Khan.
Joinuddin Khan.
Then
Claiming that Joinuddin Khan died without any issue. So I being the niece, I am entitled to the land.
how?
And we are claiming, yes, my lord.
Of 3 bighas, 3 katha 9 lecha.
Yes, my lord.
But Joinuddin Khan, as per the plaintiff, had 5 bighas, 2 katha 4 lechas.
5 bigger, 2 katha, 4 lesser.
Ah.
So our claim is this. By registered gift deed, Joinuddin Khan given to my father land measuring 3 bigger, registered deed, exhibit 4, and remaining land was given 2 bigger, 2 katha, 4 lesser by oral gift.
To you.
to my father. So now what happened, my lord? The deed was registered in the year 21/9
How much you have by registered deed? How much?
by registered deed 3 bighas, my lord.
3 bighas.
Yes, my lord.
And
Remaining, my lord, 2 bigha, 2 katha, 4 lesa by oral gift.
by oral deed.
Oral gift. So entire land comes to us.
Then
But she is claiming the entire land, but if that land be measuring 3 bigha, 3 katha, 9 katha.
okay. Now
Out
what
of
does
that,
the trial court hold?
my lord.
What does the trial court hold?
The High Court hold that he initially, my lord, first trial court agreed in our favor.
No. Not
suit was-
initially. Let us not go by the initially.
Suit
What was held? No, Mr. Sikh.
my lord.
What was held by the trial court subsequently when it was finally disposed of?
My lord,
Yes.
deferred.
Yes. What was held? I don't want to tell me. Was
Madam.
the suit allowed or dismissed?
Just 1 minute. The
Huh?
suit was up. Suit was up.
So trial court allowed the suit. Against that, you filed an appeal.
Yes, madam.
Appeal was dismissed.
Yes.
So you were here.
Yes.
As regards 3 bighas of land is a registered document.
Yes.
What about the 2 bighas, 2 katha, 4 lecha? You could not prove the oral gift.
Oral gift, my lord, in Muslim, as per Muhammadan gift, my lord, oral gift is permissible. And what
No,
happened, my lord,
permissible, but
we adduce evidence.
the fact that you could not prove, both the courts held that there was no delivery of possession. So that is a finding of fact arrived at in respect of 3 bighas as well as 2 bighas, 2 katha, 4 lechas. However, the question which is here is as to whether without even a delivery of possession by virtue of the deed of gift which is registered, can transfer of right happen to you? That's the question. Okay. Now, what is your submission on this? That is it permissible or not in view of section 129 of the Transfer of Property Act?
129, my lord, that is the substantial question formulated by your lordship.
Understood.
Possession-
I know that.
Possession
So
is
I'm.
necessary.
Huh?
Delivery of possession is necessary. That is regarding this Transfer of Property Act.
What does it say?
My lord. Let us- May I read section 123, my lord? As per how effected. 122 is the gift defined,
No. That is not the question.
my lord.
Whether 129
Yes.
affects your right to get the benefit under 123 is the question.
Yes.
Because you have already got a registered gift. Now, gift has been defined where?
Gift in Transfer of Property, my lord.
Where?
Section 122.
No.
TP Act. 122.
One 123 is how it is going
As
to be
per how
effective.
effected.
But what do you say about one
Before that,
129?
my lord,
And
acceptance
shall
funds
be
to be
deemed
made.
to affect any rule of Mohammedan law. How does 129 affect your right? The fact that there has been no delivery of possession is there is nothing that is already settled. I can't touch. Now the question is, without delivery of possession, can there be a valid gift in view of section 129? Or section 129 overrides 123?
Look, regarding delivery of possession, madam, your lordship, my humble submission before your lordship is that this matter remanded twice to the court below. And lastly, my lord, it was remanded. On remand, my lord, we were allowed to produce the gift. The plaintiff did not amend the plaint against this deed. Deed was not challenged. Now the question is regarding this possession, that there is no evidence that we have got it possession. But my humble submission before your lordship, it was registered in 1981. And in that it itself, my lord, your lordship would be pleased to see it is in Assamese. The most of the Arutokol. So that the delivery of possession regarding the from the deed itself clear. Now question is this, my lord, that your lordship pointed out that it is a appreciation of evidence your lordship cannot touch. But my humble submission before your lordship, if
But that is not a question framed today.
my lord, that is there, but that is
That is not there in the order.
my lord, that may not be in the order.
Then
my
I
lord.
cannot go
But-
into
but
that.
your lordship would be pleased to see. When I filed this RSA, your lordship done this, but that issue, that's
But what proof did you give?
Taken.
So you have given up your hope as regards two katha, 4 lectures. You have nothing to say. You are only as regards the 3 bighas of.
Very difficult. Now your lordship would be pleased to see that in 81 deed was executed, and 81 the deed itself said that delivery of possession. Now question is this, my lord. I have framed this substantial question of law in my memo of appeal. But your lordship was pleased to frame this issue. But your lordship later. But now my question is this, my lord. If something is decided, no doubt it is a matter of evidence. If something is decided perversely, I will humbly submit before your lordship. Perverse on record finding is also substantial question of law. So if that is so, my gift is not considered at all, and is
Then why didn't you ask the court at that point of time all along? We are in 2000. This was done in 2008. 16 years down the line. Why didn't you ask for reframing of the substantial question of law?
my humble submission before your lordship is this.
Okay, take your seat. Yes, Mr. Konigo.
My lord, I am extremely sorry, my lord.
What?
File has been taken.
Fantastic. Okay. You see, you have any judgments?
My lord, yeah, I refer to your lordship. It's a Madras High Court judgment.
No. Madras, the Supreme Court judgment.
Referring Supreme Court, my lord.
Yes, what is it?
My lord, the Madras, my lord, it is EIR 1995 Madras 415. My lord, I am referring to para 21.
What does it say?
Para 20. It is said that the possession is not the requirement. of a Mohammedan king.
Okay, let me dictate.
My lord, your lordship, that para 21, my lord, continuing.
Heard Mr. M.A. Sheikh, the learned counsel appearing on behalf of the petitioner, appellant, Mr. A. Konikar appearing on behalf of the respondent. This is an appeal under section 100 of the Code of Civil Procedure, challenging the judgment and decree dated 24/9/2008, passed in title appeal number 36 of the 06 by the Court of the Civil Judge Borpeta, whereby the judgment and decree dated 17/7/2006, passed by the learned Munsif number 1 Borpeta in connection with title suit number 12/2000 was upheld. This court, by the order date 19/2/2020, admitted the instant appeal by observing that by formulating a substantial question of law as to whether a gift deed executed in terms with section 123 of the Transfer of Property Act, there is a requirement of delivery of possession to constitute a valid gift. For ascertaining as to whether the said substantial question of law arises in the instant appeal, this court finds it relevant to take note of the facts which led to the filing of the instant appeal. The respondent herein, as plaintiff, had instituted a suit against the appellants herein, against the predecessor of the appellants, or the appellant,
Against the appellant.
or the predecessor.
Ah,
No,
against the-
predecessor. Mohammad Sattar, Iman Ali, and how many were there? You only 2 persons are here.
My lord, 2 persons were there, my lord. Subsequently, other sons were taken.
Against the
Attar and Iman Ali, yes.
against the
initially was
respondent number, against the appellant number 1 and 2 herein. Seeking declaration of the right of her right, title and interest, as well as khas possession in respect to the land described in Schedule B to the plaintiff. The plaintiff also sought for a permanent injunction. From the facts narrated in the plaint, it reveals that the plaintiff claimed to be the daughter of one Nayan Ali Kha KH. And the Schedule A land originally belonged to the said Nayan Ali Kha and Mazam Ali, who were both sons of Tahar Ali. After the death of Nayan Ali Kha, the name of the plaintiff was duly mutated as the legal heir. Along with the plaintiff, the name of one Aimona Khatun was also mutated as the legal heir after the death of Mazam Ali, inasmuch as the said Aimona Khatun was the wife of late Mazam Ali. Subsequently, the subsequent thereto, Aimona Khatun expired, and the name of leaving no heir. It was also mentioned that one Joynal Uddin Khan,
Joyanuddin.
Joynal, Joynal, Uddin Khan, who was the son of Tasurari, was mutated in connection with 5 bighas, 2 kathas, 4 lechas of land out of the land mentioned in Schedule A. The said Joinuddin Khan expired, leaving no legal heir except the plaintiff. And as such, the plaintiff claimed to be entitled to the properties of late Joinuddin Khan. It was also mentioned that after the death of Joinuddin Khan, the name of one Kachu Sheikh was mutated.
Kasu or Kasu?
Kansu, Kasu, Kanchu, was mutated as the shareholder in place of Joinuddin Khan on 14/9/93. And pursuant to the death of Kachu Sheikh, the names of the plaintiff defendants who were the sons. Your names were also mutated.
Yes.
Were mutated. It was mentioned that on 15/3/1995, the defendants dispossessed the suit land on the strength of the mutation. It was alleged that late Kasuse had collusively mutated his name during his lifetime in connection with the lands of late Joinuddin Khan. It is on account of the defendants denying the title of the plaintiff. The suit was filed seeking declaration of the right title and interest, as well as for khas possession evicting the defendants from the suit land, semicolon, for declaration of the order of Chita mutation dated 14/9/93 as illegal, void, and inoperative in law, semicolon, an order for sending a precept to the revenue authority for correction of the records, permanent injunction, etc. Pursuant to the filing of the written claim, you filed your written statement.
Yes, madam.
Written statement was filed by the defendant numbers 3 to 9. Where the defendant number 1 and 2 did not file. Huh?
Yes,
File
madam,
to-
they filed.
Where is it? You have not enclosed there.
My lord, it is the latest one, my lord, I have filed. Earlier it was filed.
What
Because
earlier?
The matter was
Earlier.
demanded.
File it.
It is the latest. One and two in earlier.
The defendant numbers 1 and 2 filed a joint written statement taking various preliminary objections. It was mentioned, pursuant to denying the statements and allegations made in the plaint, it was stated that the plaintiff and the defendants are from one and the same ancestor, namely Kudrat. Kudrat.
Yes, madam. Kudrat Khan,
Kudrak. Kudrat.
RAP.
Khan. Hussain. The said Kudrat Khan had two sons, Tahar Ali, Tahar Khan, and Osman Khan. Tahar Khan died leaving behind three sons, namely Mazam Khan, Nayan Khan, and Jainuddin Khan. Whereas, on the other hand, Osman Khan died leaving behind his sons Jasim Khan and Kansu Khan. The plaintiff is the daughter of Nayan Khan, and the defendants are the sons of Kasu Khan. It was further mentioned that there was a civil suit between late Jainuddin and Aimona Khatun in the civil court, wherein Jainuddin got a decree against Patadar Aimona Khatun over 5 bighas, 2 katha, 4 lechas. In respect of Patta number 39 of Dag number 484 of village Motonga, where the total area of land is 13 bighas, 1 katha, 5 lechas of land. On the basis thereof, the name of late Jainuddin Khan was recorded in the Patta over 5 bighas, 2 katha, 4 lechas by the Revenue Authority on 13/8/76. It was further mentioned that as Kasu Sheikh and his family members were nursing late Jainuddin Khan, he gifted the land measuring 5 bighas, 2 katha, 4 lechas to Kasu Sheikh orally on 15/4/93 in presence of witnesses. It was further mentioned that the gift was duly accepted by Kasu Sheikh, and the possession of the land being delivered, the said Kasu Sheikh gladly took possession of the land on the same date of the gift. However, the revenue authority, instead of granting the mutation by right of gift, recorded it wrongly in the chita as sharer. It was also mentioned that the land was gifted to Kasu Sheikh by Joinuddin, and thereby the said Kasu Sheikh acquired perfect right, title and interest over the said land. Where is it? Registered gift.
No, my lord, thereafter, my lord, on remand, my lord, we taken the plea. Subsequently, we taken the plea that there is a registered. At that time, it was not.
Where is your registered sale here? How
My
can it be? You have not taken the plea. You amended it.
My lord, your lordship would be pleased to see the latest written statement I have filed.
Oh no,
That
there is
is
no
at page
amended written
60.
statement. Why? What is all this thing? No written, nothing
Page
has been
69.
mentioned to the effect.
Page 69. Your lordship.
What?
Page 69 of my memo.
That is the response number 3 to 9.
3 to 9.
Not for 1 and 2.
My lord, 3 to
We
9.
are only 1 and 2.
1 and 2, all right, my lord.
The
1 and
appeal is by 1 and 2.
2. My lord, 1 and 2 did
Mr.
not.
Sheikh, appeal is by 1 and 2. 3 to 9 has not come. It is also seen that another written statement has been filed by the defendant numbers 3 to 9.
They are also in the same footing, my lord.
Maybe.
They are also son.
So what?
They are also son of Kansu Sheikh, my lord.
Sorry. In the said written statement, which was filed on 26/4/2006. Earlier written statement, it is relevant to mention that the said defendant numbers 1 and 2, who are the appellants herein, had filed the written statement on 6/7/2000. The record further reveals that on 26/4/2006, another written statement was filed by the defendant numbers 3 to 9. In the said written statement, another very pertinent aspect has been brought in, which completely is contrary to the statement made by the defendant number 1 and 2. Inasmuch as the defendant number 1 and 2 categorically mentioned that on 15/4/1993, late Joinuddin Khan gifted 5 bighas 2 katha 4 lechas of land orally to late Kachu Sheikh. But in the written statement filed by the defendant number 3 to 9, it was mentioned that late Joinuddin gifted land measuring 3 bighas by registered deed number 1232/81 dated 21/9/81, and the rest 2 bighas 2 katha 4 lechas to Kachu Sheikh orally on 15/4/93 and delivered presents in presence of the witnesses. the suit in the meantime. Initially, this court further finds it very pertinent to mention that initially the said suit, in the said suit, the defendant numbers 3 to 9 did not file any written statement. But the said written statement was submitted pursuant to the decree, pursuant to the remand being made by the learned First Appellate Court. First, it is further relevant to take note of that even after the the written statement filed by the respondent number, defendant number 3 to 9, no fresh issues were framed.
No.
No fresh. The learned, on behalf of the plaintiff, 3 witnesses were examined, and on behalf of the defendant also, the same number of witnesses were examined. Both sides adduced documentary evidence. Issue number 4 and 7 are very relevant for the purpose of the instant dispute, in as much as issue number 4 relates to as to whether the plaintiff had right, title, and interest as legal heir of Noyan Ali and Joinuddin Khan over the suit land. And issue number 7 was as to whether Joinuddin Khan gifted the land measuring 5 bighas, 2 katha, 4 lecha to Katsu Sheikh. The learned trial court, while deciding the issue number 7, observe that in the original written statement which was filed, there was no mention of the registered deed of gift. Further to that, Exhibit 4, which was the registered gift deed dated 21/9/81, was not proved in terms with Section 68 of the Indian Evidence Act, inasmuch as the defendants failed to examine any of the attesting witnesses to that effect. In respect to the oral gift, that it was observed that the defendants failed to establish the fact by examining the material witness accordingly. The issue number 7 was held against the defendant, holding that the defendants could not prove that Joinuddin Khan gifted the land measuring 5 bighas 2 kata 4 leches to Kachu Sheikh. The issue number 4 was decided in favor of the plaintiff on the basis of the evidence on record. On the basis of the said 2 issues, the other issues were decided and the suit was decreed on contest. Being aggrieved, being aggrieved, all the 9 defendants filed an appeal before the court of the civil judge, Borpeta, which was registered and numbered as title appeal number 36/06. The learned First Appellate Court, by its judgment and order dated 24/9/2008, dismissed the appeal. While deciding the issue number 7, the learned first appellate court was decided by the first appellate court against the plaintiff, against the appellants herein, on 2 grounds. The first being that there was a requirement of delivery of possession as the gift pertained to, as it was a gift by, in terms with the Mohammedan law. And the second is that the exhibit 4, which was the gift deed dated 21/9/81, has not been proved in accordance with section 67 and 68 of the Indian Evidence Act by calling at least one attesting witness for the purpose of proving its execution. It was further observed by the learned first appellate court that the DW1 had categorically revealed that he was neither present at the time of execution of Exhibit 4, nor does he know who put signature and thumb impression in Exhibit 4. It was also observed that the defendants also failed to adduce convincing evidence regarding gift of the part of the suit land orally to Kasumia. On the basis of the above, the issue number 7 was again decided against the appellants therein. And the issue number 4 was decided in favor of the plaintiff. The learned first appellate court also upheld the decision of the learned first trial court insofar as holding that the mutation order passed on 14/9/93 in favor of late Kasusek was illegal. The learned trial court, first appellate court, also turned down the plea of adverse possession, which was also taken by the defendants. On the basis of the above, the appeal was dismissed and the instant appeal thereupon being filed. File C to be. Now, Mr. How do you know about this thing? The person who adduced the evidence about this deed?
It deduced that he was present here.
No, you can't be. You were not present. He was 36 years old on 10/3/2006. And he was present as 1-year-old baby. 81.
Evidence I have not looked into.
Huh?
Evidence I do not look into, my lord.
No, but then also.
But it is exhibited, my lord, that was
That
originally.
you see what had happened. Initially, it was oral. When it was remanded back, then the defendant numbers 3 to 9 came into the picture. They filed a written statement.
They were not party.
Understood. They came to the picture later on. And then they filed a written statement in 2006. And along with that, they adduced this document as evidence by which the defendant number 2, DW2, adduced this evidence. What is his name? I'll tell you. Iman, what is his name? Iman Ali. Iman Ali. He was the DW2 who only adduced this document. Because there was earlier evidence was not there. There's all along oral it was going on. All the defendant evidence went with oral. Now this evidence is now being brought in by this person who was 36 years old in 2006. So he will be 10 years. 81. Very good. PDP 2. Let me come back in 5 minutes. Now the question therefore arises as to whether the substantial question of law which have been formulated by this court is duly involved in the instant appeal. I've heard Mr. M.A. take the learned counsel appearing on behalf of the petitioner appellant and Mr. A. Khanikar appearing on behalf of the respondents. The substantial question of law which have been framed is as to whether in respect of a registered deed, there is a requirement of delivery of possession, which is otherwise the mandate in terms with section 149 of the Mohammedan law, which stipulates that a gift which stipulates the three essential conditions of gift. If this court the said substantial question of law, in the opinion of this court, would be only involved if the gift deed was proved before the learned courts below. Both the courts below categorically held that the gift deed, which is Exhibit 4, was not proved in accordance with law. At this court finds it relevant to take note of that Section 67 of the Indian Evidence Act 1872 categorically mandates that if a document is alleged to have been signed or have been written wholly or in part by any person, the signature or the handwriting of so much of the document as is alleged to be in that person's handwriting must be proved to be his handwriting. This court further finds it also very pertinent to observe, take note of Section 47 of the said Indian Evidence Act of 1872, which stipulates as to when the opinion as to handwriting would be relevant. The said section postulates that when the court has to form an opinion as to the person to whom, by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed, that it was or was not written or signed by that person is a relevant fact. The explanation to the said section further mandates that a person is said to be acquainted with the handwriting of another person when he has seen that person write or when he has received documents purporting to be written by that person in answer to documents written by himself or under his authority and addressed to that person, or when in the ordinary course of business documents purporting to be written by that person has been habitually submitted to him. In the instant case, the defendants all along, till the suit was remanded back for fresh trial, had taken a stand that there was only an oral gift by late Jainuddin Khan on 15/4/1993. It was only on 10/3/1996, 2006, that the defendant witness number 2 submitted his evidence, enclosing therewith and exhibiting therewith the registered deed of gift which this court had also taken note of the appreciation of evidence by the learned trial courts as well as the first appellate court, more so in respect to the evidence given by the DW2. This court, having perused the said judgments, is of the opinion that there is no error or there is no perversity on the part of the learned courts below as regards the appreciation of evidence in respect to exhibit core being proved in accordance with law. The consequential effect of the above observation is that when the exhibit core document has not yet been proved, the question of deciding as to whether there is a requirement for delivery or possession, even in a case of a registered gift, which is the substantial question of law formulated, is not involved in the instant appeal. Consequently, this court finds no merit in the instant appeal, for which the same stands dismissed with cost of 11,000. In addition to that, the plaintiff shall be entitled to cost throughout the proceedings. Mr. Sheikh, you had a case on that question,
My lord,
but
when I
not
had-
on this point.
when I had the case, your lordship said, then
I
was very less
can't, no,
because
I
where
can't.
agriculture is part of
No,
the-
no. You had a case on that point. The point is, your judgment I've taken out, 2014 10 SCC 459. If this was not there, I would have. But when the document has not been proved, I can't do that.
And
One.
another point is this, my lord, that oral
too, there is
oral
nothing.
PC, that was not there. No, my lord, my one submission before your lordship is this. In every second appeal, my lord, your lordship will not take otherwise. What I am noticing, and bar is noticing, that every case, my lord, in second appeal, dismissed with cause, it will go a message, the people will not dare to come.
No. Just for example,
This is
no.
policy.
Now tell me one thing.
My lord.
Why I'm saying it.
Regularly, my-
No. Mr. Sheikh, kindly come to this. If you file a suit, it will be allowed with cost, dismissed with cost. Do you know the reason why? Tell me. Appeal you file, it will be allowed with cost or dismissed with cost. The reason is section 35 of the CPC, which categorically mandates that there has to be a cost. Not for the purpose of there is anything to that effect, that you have misled the court, nothing to that. But this is a cost which is there for the purpose of the proceedings.
No, my lord, with due respect to your lord,
Hmm.
it is also observation of the Honorable Supreme Court in many cases that imposition of cost should be sparingly done.
Then against this, I do one thing.
My lord,
No, for 11,000 for you to go to Supreme Court would be difficult. I make it 55,000, then it would be easier for go to Supreme Court. Then there will be the interest of the appellant to go to Supreme Court.
my lord, I could not follow, my lord.
You see, with 11,000, your client may not like to go to Supreme Court. Cost. Because 11,000 going to Supreme Court will be more expensive. I make it 55,000, then you can very well go to Supreme
I'm not on that, but that was my first point, that my persons are 4 persons, so cost may be less. That was one thing. But regarding this, my lord, regarding cost, what I want to place before your lord is that generally cost is to be imposed sparingly. That is the Supreme Court judgment in many judgments.
That is why I go to Supreme Court against this. I am not.
Not, that is not my.
As
signal.
per, no, Mr. Sheikh, kindly see paragraph section 35.
Yes, my lord, 35 is with me.
Yes, what does it
Subject
say?
Subject to such conditions and limitations as may be prescribed, and to the provisions of any law for the time being enforced, the cost of an incident to all suits shall be in the discretion of court. Discretion of court. That is why, my lord, if we take this discretion of court, your lordship may or may. That is the thing. Discretion of court, and court shall have full power to determine by whom or out of what property and to what extent such costs are to be paid. So, my lord, regarding this 25,000, 11,000, 5,000, 3,000.
No, no,
that is also
11,000
with your
minimum.
lordship, with your lordship, that determined by whom or out of property and to the extent of costs are to be paid, to give all necessary direction for the purpose aforesaid. The fact that the court has no jurisdiction to try the suit shall be no bar to exercise of such power. But the court directs that any cost shall not be followed the event, the court shall set it written in writing.
When I don't give cost also, I have to state reasons. Why? You see?
Hello.
If I don't impose cost also, I have to state reasons.
Your lordship, may I have this habit? That exactly if your lordship found that it is unnecessary litigation,
Absolutely.
if it unnecessary litigation with some ulterior motive, knowing very well there is no merit in it, they have come, then it is another thing. But your lordship, starting from civil suit, your lordship, the auditory people comes to the advocate. In my case, I am submitting. In my case, written statement submitted by the learned advocate in the initial stage say that oral evidence, oral deed, and subsequently another set of defendants stated that there was registered deed. So original written statement definitely was to be amended. That was not done. That is on lacuna. So, my lord, public in general.
Now the interesting part is, The defendant number 3 to 9 who submitted that there is a what you call written stay or written registered deed, registered gift deed, they did not submit the second evidence. It was the first defendant number 1 and 2 who submitted the second evidence, which is completely contrary to their statement without being amended.
So, my lord, my humble submission before your lordship. Why Honorable Supreme Court? Why Honorable Supreme Court time and again said that cost is to be imposed sparingly? Here is the reason. Because, my lord, the client, my lord, who will pay the cost?
Right.
Question is this, who will pay the cost, not the advocate? The advocate who conducted the case in the civil side, in the original suit, he will not pay the cost. I will not pay the cost. Cost will be paid the client who came to the advocate, for filing the litigation. So wrong committed by advocate are free.
No.
No
it is
advocate is giving
no,
the
Mr.
cost.
Say, kindly appreciate.
My lord.
It is not the question of the advocate being wrong to that effect in this case, or for that matter, but one has to also think of restitution for them. Either of a party. Just for example, you file an appeal, you win the case. Saying today you are winning the case. I'll impose cost upon him. For the entire proceedings, he will get the cost. You will get the cost.
Well, I'm not on that, my lord. Either party will pay the
Has
cost.
to pay.
But cost will be paid by the client, not the advocate.
Obviously, the client has
That
to
is why, my
pay.
lord,
They are the
that is why
litigant.
My humble submission before your lordship.
Hmm.
Written statement is not amended. If the, let us take it. If the
Mr. Sheikh,
advocate
Mr.
advisement,
Sheikh, you are at liberty to say whatever you like at a later point of time, complain whatever you like. I'm not going to change anything you want. I
No,
can
no,
just.
I'm not- I'm
No,
not-
Mr. Sheikh, kindly, I'm telling you. We are losing. Every minute is losing. Now, if you want to pay cost at your expenses, you want to make anything, say it, I would do so, but then I will impose the cost on you. You want that? I can do that. Then don't, because we have other matters. There are other
my
councils
lord,
waiting.
I'm sorry to.
No, Mr. Sheikh, you are at liberty to come to my chamber to discuss about the cost. You are at liberty,
My lord,
but not at the court's expense now.
my lord, thank you.
Every minute is an expense for them.
I'm thankful to your
Yeah.
lord. Deep lord. Oblige, your lord.
Yes, Mr. Sharma. What is this type of litigation?
My lord. Nothing has been suppressed by the court, my lord.
That is not
I
a
have
question
filed a
of
petition.
suppress.
I have filed a petition.
Now let me come here. Kindly come to this paragraph. Paragraph 6 of your petition.
If I would have suppressed something,
Paragraph 6 of the petition.
for the case that is of 185 had filed an application for order highly some of the 2 points. By petition under one of the order was for 6. So all the what is the the my client is highly case for 50% of contract.
So what? But how can you get a suit stayed for all this while? When the case has been dismissed for default, why are you again challenging the same order here?
I don't. It's for default.
You dismissed for default, you want the restoration, you filed the restoration was dismissed. Then why are you again before this court?
Everything has been mentioned by me.
Why?
Everything has been mentioned by me. But at the time of my
On one hand, Mr. Counsel, you have gone for restoration of the other matter.
restoration was also
No, you have gone for restoration of the other matter in 2014, 2016. You have filed miss case number 640 of 2014. Understood, it has been dismissed. But why you are continuing both the proceedings together here?
Already that was dismissed for default. Firstly, I don't even know whether that case, I don't remember it now. Whether the case proceeding was admitted or not. Whether it was admitted or not, that is also.
I'm not concerned with admitted. When there is a matter being filed out there, first of all, you have a practice of pretty long practice, so you must be knowing when a review petition is dismissed, your order has to be challenged with that original order. Now, the original order has already been dismissed by this court on a dismissal. Then why did you file against this?
That is fit for default. My dismissal for default.
So what?
It is not res judicata. Dismissal for default will not amount to res judicata. It is dismissal for default. The court said that now it is dismissed, but that means court has not taken note of my case. It is dismissal means that there is no.
So you can again
there
come.
is no. Why not?
No, again you can come.
Suppose my suit is dismissed for default. I have two options. Either to get the restored, or I can file a case to.
Can you?
I can, yes.
Can you? If it is done under Order 9 Rule 8, can you?
Only
If it is done under Order 9 Rule 8, can you file a fresh suit?
only if the, only on
If
not
only
same
no-
cause of action.
What?
Only not on some same cause of action. If it is there,
Isn't it on the same cause of action you have filed?
why not this?
30/11/2005.
Why not this is within petition? Well, I will allow. Why not? There are several cases for the High Court. It says that yes, if previous revision petition is for default, in that case, it files case.
Is it for? Show me that. Which
Of course,
court
my
has,
lord, that is.
which court has stated
Yes,
so?
my lord. Of course, my lord, it is under 151, 115 of the.
No, no. 115, a 115 petition, if it is dismissed for default, you can file a fresh 115. Show me.
This is what court.
Which court has given that? Which court is this? With due respect to this court doesn't know what is section 12 of the CPC. Huh? They are not aware of what is section 12.
Really, my lord.
We are not concerned with section 11. We are concerned with section 12. These basic things this court should know before making that. We are not concerned with the res judicata. We are concerned with being barred.
Section 12 also. But there the plaintiff failed by root from to a further suit in respect of particular cause of action. They are not be entitled to the suit in respect of such cause of action before the court applied. But regarding a suit, regarding a not for
Revision First of all, you can't apply that here. This is a supervisory jurisdiction. First of all, the CPC doesn't apply here. It is a supervisory jurisdiction where it is a case you have taken this court for granted. Once you have filed this and now and that is why when the first day the matter came up before Justice Chaudhary, as it then was, he had put a specific query upon you. First, whether order sought to be reviewed by the learned trial court has merged with the order dismissing the revision petition. Secondly, whether order passed by the learned civil judge can be reviewed by the subordinate authority, namely Munsif. You were to satisfy. You didn't satisfy anything, only notice has been issued. Yeah, that is why.
All those points are regarding
Mr. Sharma,
No, my lord.
don't spoil your reputation any further before this
I have
court.
filed a bogus litigation. I'm always
It is absolutely a bogus litigation.
My lord, these are the points which need to be argued, my lord.
Which point?
Points whether, first of all, the revision petition, first division petition, which for default, whether it bars second division petition,
Yes,
whether it bars not.
yes.
I
I'm doing it now along with the court.
It's immediately, my lord, in one division petition, first regarding appeal. Court said that if the appeal is dismissed for the court, it means that there was no appeal. It amounts to filing on no appeal. Because nothing has been laid down by the court. Court has laid down no law has been laid down by the court. So by taking that one that once it is court does not lay down any law. That is why no decision has been made. No decision has been made, and the court has not taken up the matter. That is why court has not
So you can keep on filing it.
no.
You have dismissed for default, second
No,
appeal.
no,
Tomorrow dismiss for default, you file another second appeal.
there is no
A
provision for
suit has
that.
been dismissed for default.
No,
Yes.
there is no
Therefore, a suit filed and which has been dismissed for default under Order 9 Rule 2, Order 9 Rule 3, then you can come under Order 9 Rule 4. There's a difference out there. But Order 9 Rule 8, which is the court fix, you cannot. But we are not concerned out here. We are exercising 227 when it has been dismissed, you cannot.
that is why. So
Matter
once
ends
my
there.
lord- once my lord it was told, I have no way to restore the matter also. There is no
Go
provision.
to Supreme Court.
There is
Ask
no-
for restoration from this court, which you even failed out here.
I have filed, but
No,
there is
no.
provision
You,
to restore.
no, you filed for restoration and you did not appear. Kindly appreciate that. You file a restoration, you have not appeared. You have got the matter stayed of a suit being stayed out here of 97. You got a suit stayed out here. All this while by filing this bogus petition.
My lord, whether my lord, there is any merit in the matter, my lord.
No.
My lord, I have
Merit is
I have
zero.
not been allowed to elude evidence, my lord. I have not been allowed. to
I'm not
elude
concerned with your
evidence.
evidence being allowed or no. No, no, you have no merit in this matter. You may have a merit in the earlier matter. I'm not concerned. I'm not concerned with the earlier matter. You have been given the opportunity for filing an application for restoring. You filed it. Then also you did not appear. It got dismissed for default. You take let your person go and take action against the lawyer who have done it. But then also you cannot come out here. This is a strict message has to go to people. You can't come up with this type of method. This is a flagrant violation. The instant application under Article 227 of the Constitution is a flagrant violation and a misuse to the powers under Article 227 of the Constitution by misuse of the powers of filing application under Article 227 of the Constitution. The reason being that the petitioners herein had initially against the order dated 30/11/2005 had filed a petition before this court, which was registered and numbered as CRP case number 33/2006. This application was dismissed for default by an order dated (8/9/2010). The petitioners herein not only filed an application challenging the order dated 30/11/2005 before this court, but the petitioners simultaneously also filed an application under section 114, read with order 47, rule 1, seeking review of the order dated 30/11/2005. It is pertinent to mention that this review application was filed on 4th of January 2006, whereas the revision application which was filed before this court was on 7/3/2006. The revision application, as stated above, was dismissed for default on 8/9/2010. Meaning thereby, the said order which was passed on 30/11/2005 stood confirmed by this court by the order dated 8/9/2010. The petitioners did not stop there. On the other hand, tried to mislead the court before the learned trial court, that is the court of the Munsif number 2, Guwahati, stating therein that the revision petition number 33/06 was pending before the court.
We have noted that.
The order says,
No, we have noted. The opponent had said. The opponent has said that our opponent had said that the revision petition is pending. It is not.
the petitioner ought to have, therefore, in view of the dismissal of the application, dismissal of CRP 33/06 by the order dated 8/9/2010, ought to have, therefore, stated before the learned trial court that the revision application has been dismissed. However, this aspect of the matter was not brought to the attention of the learned trial court. And this aspect can be seen from the very order passed by the learned trial court on 24/5/2013, rejecting the review application, stating that the civil revision petition is pending before the High Court. Against this order, the petitioner herein, knowing fully well that the order dated the CRP petition number 33/06 was already dismissed, again approached this court by filing the instant writ petition, instant application under Article 227 of the Constitution, challenging the order dated 24/5/2013, as well as again challenging the order dated 30/11/2005. And thereupon, the said suit, being title suit number 979/2006, have been stayed. What is the suit? Earlier it was 97, nah?
Not it. 229 of the 2000.
Huh?
Original suit was 2000.
Title suit number 979/2006,
Got it.
which was earlier numbered as
229.
229/2000 stayed till date. This court further finds it relevant to observe that at paragraph number 6 of the instant application, it was stated that the plaintiffs were under the impression that the civil revision petition filed by them before this court was pending, and as such they did not get relief in the said revision petition. As such, they did not take steps for filing this revision petition. This court further finds it also relevant to take note of the submission of Mr. R.K. Bhuya, who submitted that the petitioner have also filed an application for restoration of the CRP number 33/2006. Being miss case number 640/2014. The said application was also dismissed for non-prosecution. It is also pertinent to take note of that all these years, for the last almost a decade, there has been nothing has been placed on record by filing an affidavit about the dismissal of the restoration application. The fact that the petitioner filed an application for restoration, which was dismissed for default. From the facts above stated, it is very clear that the petitioners herein have abused the process of the court by filing the instant petition, by challenging an order which came into existence in view of the failure of the petitioners to inform the learned trial court that the revision application which was filed challenging the order dated 30/11/2005 have already been dismissed for default. That is my finding. That is my finding. I'm nothing to do.
We were not aware about this.
I'm not, that is my
We were
finding.
not aware about it.
You,
And it would have been
this is my categorical finding. The petitioner again have challenged the order dated 30/11/2005. And today, when the matter is being taken up, had the audacity to submit to the effect that a second revision petition under Article 227 is again maintainable if the earlier revision petition under Article 227 is dismissed for default. The said submission, in the opinion of this court, is totally misconceived and preposterous. Taking into account that this is a complete abuse of the process by which the petitioners have misused the process of the court, this court dismisses the instant petition with cost of rupees 50,000 to be deposited before the learned trial court by the petitioners on such date as this court fixes herein below. This court have duly taken note of that this court had stayed the further proceedings of title suit number 979/2006. The said in the court of which court?
Munchip 2.
Munship number 2,
Two.
Kamrup Metro at
Metro.
Guwahati. Pusto. This order of stay is vacated and the parties herein are directed to appear before the learned trial court on 14th of June 2024. On that date, the petitioners herein shall deposit the said cost of rupees 50,000. The respondents shall be at liberty to file an application before the learned trial court for release of the said amount, and the learned trial court shall pass appropriate orders on that. Yes, what is this? Whether the lower appellate court committed grave error in holding that the plaintiff had right title interest over the suit land, although the sale deed by which the plaintiff purchased land is void. What? Plaintiff purchased sale deed is void.
Yes, Lord, and it is the finding of the learned appellate court also
What?
that sale deed is void.
Suit is by the plaintiff.
Plaintiff.
Plaintiff seeking suit for right title interest.
Interest and first position on the basis of my lord sale deed.
On the basis of the sale deed.
Yes, Lord.
Now what happened?
Now, our case, my lord, that the sale deed was executed by my lord the eldest brother on behalf of the minor.
Huh?
On behalf of the minor brother.
Who they?
They are the minor brothers, my lord, and it was executed by the elder brother on behalf of the minor brother and sister.
In whose favor? The plaintiff.
Yes.
Have you challenged the sale deed?
No.
Then
Now,
have the minors challenged the sale deed after becoming major?
my lord, when my lord we came to know about the my lord case, my lord, then we filed my lord counter claim.
When? In this court.
Lord.
Then what happened?
Counter claim dismissed.
Then you filed an appeal against the counterclaim? No.
No separate appeal has not.
No. Then defend numbers 1, 2. Who were the minors? Are you the minors?
Not yet.
You are the minors. Your land has been sold by your elder brother
Elder brother, he has not been made party also.
in favor of?
Plaintiff.
Okay. And when did you attain majority?
That was not. We have not especially mentioned.
No, then, you see, as per the Limitation Act, yes, 60. And counterclaim was dismissed for what?
On the ground of dilemma. A limited.
60.
59.
60.
We have discussed 59.
Huh?
We have not discussed 59.
59, how is it? That aside 3 years. You have only sought for cancellation.
Yes.
Nothing else.
Cancellation as well as right title interest and declaration of possession.
Declaration of
Confirmation
possession,
of-
you are in possession.
Plus confirmation of possession.
Confirmation of possession is only a declaration, but the question is only you are asking for declaration of your right title interest. That is also not necessary, but for the sale deed,
Cancellation of
cancel of the sale deed.
And-
But when you became major, where did the learned trial court hold it?
case 54, madam. The learned appellate court finding.
Page
Case 54, paragraph 24,
54.
paragraph 24.
Can be safely hold that any sale by dispose that the dispose partition is not however
But I am relying on new judgment.
where is you are referring to only page 24, paragraph 24.
Then ultimate final case 58 also, my lord, paragraph 27. From the above factual and legal aspect,
Page 58.
58,
Where
paragraph 27.
it is clear that though the exhibit sale deed is void, but due to non-raising of the objection by the defendants or effective or within the period, their claims over the suit land for declaration of their right title and interest and also for cancellation is hit by 59 of the limitation. Ought to have raised their claim within 3 years of attaining majority. Yes, rightly. Or within 12 years of delivery of possession, that is latest by 1987. By not claiming the same within the time even after getting knowledge, the counterclaim is prepared by the ER so far as to declaration of right title and interest and prayer for cancellation of the sale deed is barred by 59. On the above, has rightly decided to and so against the defendant and came to the conclusion they are not entitled to relief as paid for. The claim of the defendant is barred by limitation so far as demand is concerned. The declaration of right title has no role to play in spite of having a void sale deed of the forfeit share. He has perfected by the national. What is the plaintiff's case? Plaintiff's case is of adverse position.
No, madam.
They-
Their case that they have purchased the land
Huh.
and in 1975, my lord, and
And all of you were minors.
lost it,
All.
all, my lord.
Then who
And
are you? All the defendants. Nur Mohammed, Nurul. And the sale deed was executed by whom?
by one Nagor Ali, elder brother, my lord, he has not been made party in the.
No. Did he sell his right also?
That was not clear in the.
No, you have seen the sale deed. Does it say anything about his right also?
Not he. His share is there, my lord. It was my lord paternal property, my lord. So appellate court also discussed that 1/4 share is there. 1/5. He has saleable right.
How much is the plaintiff claiming?
4 বিঘা 2 কাঠা 10 less, the entire land.
Only 4 bighas, 2 kata 10 lechas.
Correct.
And your right is how much? 73.
Out of 73, my lord, all total was 70 acres of land. Out of that, my lord, some land were, my lord, gifted, and as per my lord, WS, my lord, 58 acres of land. After death of our father, my lord, 3 brothers and 11 sisters. And the elder brother sold, my lord, this 4 bighas, 2 kathas 10 lesser on behalf of the minor. And other brother and sister also not made part.
Mr. Ali, I think you properly read this matter. You have a case, but
Well-
I think we may have to
One judgment, my lord,
additionally, that question of law is not good.
if the sale deed is initially void, my lord, it's not required to challenge, my lord. The Supreme Court, my lord, giving, my lord. Ultimate findings, my lord, is 16.
It is on a different score, Mr.
Here, my lord, the husband, my lord, sold the land to wife and
Necessary for the
his
plea.
son. Is 16, my lord, last 3 lines.
See, kindly see page, see, that is why page 16,
Lord,
the last foot. It was not necessary for the appellant to specifically claim a declaration as regards the sale deed by way of amendment to the plaint. The reason being that there were specific pleadings in the plaint as originally filed that the sale deed was void.
Lord,
This is not here. There is also another earlier judgment of Supreme Court in the case of operation of Bangalore. There also the question is, you need to read the entire plaint to find out. You need not seek the relief, not only in the relief, otherwise. This is on the same premises which is void need not be challenged by claiming a declaration as the said fee can be set up and proved even in a collateral proceeding. Why you are saying it to be void?
because, my lord, the brother has no right to sell, my lord, on behalf of minor. He is neither legal guardian, my lord. He is not court-appointed guardian, my lord.
Now, what did the sale deed say?
Sale deed, my lord, exhibit 1 is the sale deed, my lord.
What does
Nothing
it
has been
say?
mentioned, my lord.
Read the front portion of it. It will say why he has sold it.
My lord, sold on the because of financial needs.
No, what? Take the word.
Likitang, my lord, Nagor Ali is the elder brother, my lord. Then, my lord, Muhammad Kul Khatun, minor. Muhammad Momela Khatun, minor. Nur Muhammad, minor. Romela Khatun, minor. All are son daughters of Iyad Ali. And Napalagor Pokhe Odokhe is what he was used, my lord. And Dangor Bhai Nagor Ali, Pita Iyad Ali, Jati Musalman. আজি আমার নগদ টকাৰ বিশেষ দৰকাৰ হোৱাৰ উপৰোক্ত বৰাবৰৰ পৰা হাতাহাতিত 2,500 টকা লৈ আমাৰ নিজ নমীয় দখল নিম্ন তহচিল বৰ্ণিত 4 বিঘা 2 কাঠা মাটি
So there is nothing mentioned for the benefit of them,
Not.
which is
Not.
otherwise a requirement.
Not.
Do you have any judgments as regards the benefit?
Yes, my lord.
Benefit of the minor, it has to be categorically mentioned.
Benefit of minors, my lord, that too by the legal guardian or court appointed guard. This is, my lord, year 1996, my lord. Here, mother sold the care of the daughter, minor daughter.
Hmm.
The Supreme Court said that mother has no right, my lord, and sale deed was, my lord,
What is the year?
year 1996, my lord. Year 1996, Supreme Court 1003. 1003. 1000.
Year
Year 1996.
1.
1003. Mithian Siddiq.
Do you subscribe to the view that the mother is not the natural guard? I'm asking you, do you subscribe to the view that the mother is not the natural guard?
As per Islamic law, my lord,
Or it's because of Islamic law?
Law.
Oh, the father is, na?
Law.
Oh, otherwise it is mother.
yes, my lord, father or my lord, grandfather, or my lord, any authorized person by the will, my lord. By the will of father or father.
The brother would not.
Mother, brother, uncle, they are not legal.
Okay. So further, it is what 359
Okay.
of the monumental law. The father, the executor appointed by the father's will, the father's father, the executor appointed by the father's will. So they are only the legal guard. Yes, Mr. Sikdar.
My lord, their claim is based on false, my
Huh?
lord, false pleading. Their claim is that the land was sold, that was not known to them, and they are all along in possession. But that is not true, my lord. Their
They are the
witnesses claiming
defendant.
that we are cultivating land through others. Their witnesses supported our claim. So they are never in possession. Till dispossessed the plaintiff.
Hmm?
The plaintiff was dispossessed in the year 2008.
You are still dispossessed.
My lord, dispossessed since the 2008 we have been dispossessed, my lord. Prior
Have you
to
got
that,
the possession back or not?
my lord.
No. Have you got the possession back?
No, my lord. Because of the stay, I think, my lord, we are not in. From the date of purchase, my
But
lord, till 19
the sale deed on the basis of which you are claiming
Yes.
is a void document.
void document, even if it is void document, they are to challenge it, my lord. They are
So
to,
that is what the Supreme Court said in
my
that
lord,
judgment.
we have also some Supreme Court judgment, my lord, recent judgment, my lord, that they have to challenge it. They have not done it. We have also.
Where is it?
My lord, Lord, you may kindly have a look at the two judgment. My lord, I am referring, my lord, first one, my lord, 2006 560 353, paragraph 28.
When was the sale deed executed?
1975.
And when did you become major?
They are saying that they are in possession in the days of their father. Absolutely false, my lord. The evidence, my lord, goes to show that up to dispossession, date of dispossession, we are in the possession.
Now kindly come to paragraph 2006 560,
Yes, my lord.
page
Paragraph.
paragraph 15 and 16.
15, my lord, section 13 of the CCB.
16. When a document is valid, no question arises of it. When a document is void ab initio,
My lord.
a decree for setting aside the same would not be necessary, as the same is non-est in the eye of law, as it would be a nullity. Para 16.
When it is valid, no question of arises of its cancellation. When the document is void ab initio, a decree for setting aside the same would not be necessary, as the same is non-est in the eye of law, as it be a nullity. My lord, in paragraph 28 has clearly said
Understood.
that when
If
there
it is voidable, can you see there's a difference? If it is voidable, if it's a case of fraud, it's a case of misrepresentation, it's a case of coercion, it's a case of all these things, then in that case, it becomes avoidable. Therefore, it says in this judgment itself that Article 59 is only in the case of voidable transactions, not void. Can you see here? In the case of fraud, it is being mentioned. Then down below, but if it is void ab initio, then the question is different. You therefore find it the same answer here. 19, you see?
96.
It is not in dispute that by reason of Article 59 of the law, the scope has been enlarged by the old so and so. By the reason the provision contained in 91 of 100 has been ordered. If a plaintiff is in possession, he may file a suit for declaration. Let me see, 18. Article 59 would be attracted when coercion, undue influence, misappropriation of fraud, which the plaintiff asserts is required to be proved. Article 59 would apply in the case of such instrument. It would therefore apply when a document is prima facie valid. It would not apply only in instruments which are presumptively valid. Now, in this case, if the brother did not have the authority, in view of 359.
question is that they have not come forward to challenge this, knowing fully well they have not come forward to challenge it.
Under such circumstances, if a deed which is void ab initio, what's the difference between a void deed and a void ab initio?
My lord,
What is the difference? Because here the Supreme Court uses two terms. If you see paragraph number 16, the Supreme Court uses the word void ab initio of your judgment.
my lord.
Para 16.
Para-
When a document is void ab initio. Whereas, if you see paragraph number 28, if a
Right.
deed was executed by the plaintiff which he was when he was a minor
Minor.
and
It
it was
was void.
void, he had two options.
Yes. That is the case in the present case, my lord. They
Can you
have-
read the language? If a deed was executed by the plaintiff
when he was a minor,
when he was a minor, meaning he executed it, then it is void. But then he can very well challenge it on these grounds. You see, somebody else signing it is not mentioned. But here, if a person has no authority, just for example, some ABCD in their name says it, is it required? If the document, wouldn't that be a document void ab initio? And the second aspect, which I wanted also, we'll consider this aspect. Another aspect of there is the judgment of the first appellate court, last portion of here, if you see. Yes, page 59. The claim of the defendant thus barred by limitation. So far as issue number 7 is concerned, that is declaration of right, title, and interest of the plaintiff, Section 27 of the Limitation Act has a role to play in the present suit and here, as the plaintiff, in spite of having a void sale deed for the forfeit share, she has perfected her title by way of inaction of the defendants. How do you perfect your title? By way of adverse possession.
My lord, we are in the possession, my lord. Since 1975 and. after
Therefore, you
2008,
perfect your title by how? If it is on the void sale.
Because of their inaction, they have not come forward knowing fully well.
No, understood. How? You will in fact perfect your title on the basis of adverse possession.
Yes, my lord.
So thereby, you are claiming on one hand the right on the basis of your title,
Right.
on the basis of the sale deed, and you are on the same time you are claiming adverse possession also.
Possession. Yes, my lord. We are in the possession, my lord. Since 75 to 2008, we are in possession. They never come. They are knowing fully well. Their evidence also saying that.
Now, in this regard, both of you look into the judgment of 2022 10 SCC 217, huh?
My lord. 2000.
22 10 SCC 217. Have a look at this. We'll take it up this matter again on when? Today is what? May. Let's take it up on 28 for
Right.
further hearing.
2022 10 SCC, my lord.
10 HST, I gave him, na? Mr. Ali, give it to
217.
there. The question is whether you can raise both the issues.
Regarding
Issue of title
and adverse possession.
and adverse possession.
In this case, my lord, 96, both my lord claim was made.
No, in that case, it was specifically said that there cannot be two claims.
Okay.
No, therefore, the second part of page 73. Therefore, I'm formulating another question of law. Third, Mr. R. Ali, the learned counsel appearing on behalf of the appellant, as well as Mr. A. Sikdar, the learned counsel appearing on behalf of the respondent. This court have ably taken note of that on 10 to 2012, this court have already formulated a question of law. During the hearing, this court found that there is a necessity of framing an additional substantial question of law. The additional substantial question of law is as to whether the plaintiff, having claimed title on the basis of a registered deed of sale, bearing deed number 2913/75, could have also raised the issue, or could have also raised the plea of adverse possession raised the plea of title on the basis of section 27 of the Limitation Act 1963. Taking into account the fresh substantial question of law having been formulated, this court fixes the matter for further hearing on 28/5/2024 at the top of the list. Yes, any more? So many lawyers. Yes, Mr. Company Secretary.
Lordship, my item number is 7, your lordship.
Oh, yes.
If it can be taken, your lordship.
Not today.
I can take 15-20 minutes. Then.
Your 15-20 minutes won't do, na, because it is 4:15.
Then fix the date, your lordship, as your party.
Yes, when do you want it?
When you want. You're suitable.
28.
No, it's too early.
Oh.
You have so many matters fixed already.
Last week, your lordship.
Right.
Yeah, we can fix it on 6th. 6th, okay?
Okay, top of the list, your. So that.
No, I won't be there on 6th, so it may not be possible. But Did you file that additional document I've asked you to file?
Yes, your lord.
You got it? You got a copy of
Yes.
that?
Right now
Okay.
we have.
Huh?
Yes. Today we don't want to trouble otherwise. So my lord,
We have
this
already
issue,
sent
otherwise it
someone
needs,
and get it filed, your lord.
it
I have sent someone from Delhi and get everything done. Already
What? You have not filed it?
filed.
We already
Filed and
filed.
served.
the pleadings part is over. No problem.
Okay. Let's have it on 18th of June.
My lord, that is
Okay.
18th of at top of the list. Top of the book.
Uh, the counsel is appearing, the petitioner in person is present. Mr. Samaria appears on behalf of the respondent. The petitioner in person requests that the matter may be taken up on the top of the list, taking into account that the matter has been substantively heard by this court. In that view of the matter is directed to be listed on 18th of June 2024 at the top of the list.
Okay. Lordship, item number 12.
Oh, yes. Yes.
This matter repeatedly this has been listed, but because of paucity of time, Lordship, it is a suit of 2006.
Huh?
It is a suit of 2006, Lordship. It is an old lady, 75 years of age.
Who is
From
the
the-
other side?
I'm the petitioner.
The
Petitioner.
appellant-
Appellant, sorry,
appellant.
appellant.
RSA.
RSA.
Oh, 12 to keep. Okay. Others may go. We'll just start
Yes.
with 12.
Yes.
Yes, Mr. Dhawar.
Lordship. For 10 years.
Yes, what? You have an urgency.
Maybe dictate my lord some other day next week, even my lord, I will be there after 35. If one case is disposed, my lord, then I will be outside.
Mr. Dhawar, the entire month is filled. I have no, means it is completely filled up. There are so many matters. I always try to finish up the top of the list if it is done. Second appeals, it takes some time also.
I will be obliged, your lord. Some case, my lord, I feel very,
Huh?
I feel better, my lord, I feel my lord, I must from a distance, like that's all, my lord.
38, 30.
30.
My lord, supplementary item number 21 was fixed for today.
What is that?
That's the MSCT case filed after 18 years.
Oh, yes. Wait. Your matter, just 1 minute. Huh? Where's the other side has appeared? 21. Huh? I remember. This is important. This is a very important. Have you served the copy, Mr.
Yes,
Mr. Das?
yes, my lord.
Now, has
Uh,
anybody appeared in this matter? 21? Is anybody appearing?
Not seen, my lord. This, that order copy has been served before the tribunal and tribunal has passed order accordingly.
Give it to me. Yes, Mr. Sahu.
No, item A was.
No. Do some social service out. In this matter, appear and assist the court. Other side is not represented.
The Valpada court has passed this order after receiving the certified copy of the order passed by this honorable court in presence of the claimant advocate.
You see, Mr. Sahu, where is he? Don't run away, wait. Mr. Sahu, what has happened in this case? Other side is not represented. It's a case of a claimant. After 18 years, no?
After
No,
18
my
years.
lord, in this case, I'm not there. I am about to.
I know that
Sorry.
you are not there. That is why I have asked. In this case, the claimant have filed after 18 years.
Yeah.
166(3) categorically mandates that the limitation was removed. And on the basis of that, there was a division bench judgment earlier which stated that there is no limitation and they can file at their wish. Thereafter, a 3 judges bench of the Supreme Court judgment, that day I gave it to you, no?
Yes. Measures Purohitar Company versus Khatunbi and others.
And you have the citation, I gave it to you.
2017 4 SCC 783.
This judgment says filing after 24 years,
That was 28 years.
28 years, and said that you cannot do this. There has to be a reasonable period. Now here, the insurance company, after taking into account that there was no claim filed for 18 years, and the claim petition, they filed an application before the court for rejecting the application claim, taking into account that, look here, it is too long. 18 years is too long. The trial court did not look on it. The MSCT court rejected it, and for which he has filed a revision. Now you have a stalwart out here for the purpose of the insurance company. So there's none for the claimant. So I appoint you as an amicus. You have to assist the court as to whether this order, what is to be done by the court. Okay? Social service. You take this. We'll hear it on some other day. I'll extend the order now. Pursuant to the order passed by this court on 1/5/2024, the learned counsel appearing on behalf of the petitioner have also drawn the attention of this court that the learned court of the learned member MSCT Gwalpara have been duly informed about the pendency of the instant proceedings, and there is a stay order so passed by this court. Did I grant the stay?
Yes.
Yeah. Good stop. However, the claimant having due notice also have not appeared before this court. Good stop. Taking into account the above, this court had requested Mr. Essau, the learned counsel, as to whether he would mind to be an amicus to assist the court in the instant proceedings, taking into account that a very important question of law is involved. Law is involved. The learned counsel, Mr. Sahu, has duly agreed to assist the court in this. Accordingly, list the matter again on 25th of June 2024. The registry shall show the name of Mr. S. Sahu in the cause list as an amicus in the matter, and also furnish a copy of the instant petition within 7 days. The cause, cause list.
Am I to furnish the copy of the?
Oh, the interim order passed earlier shall stand extended till the disposal of the instant.
Deeply obliged.
Matter be shown as part of. The judgment is already there, the 96 judgment. There is a 2 judges. This judgment which referring is a 3 judges. Because this order which this court will pass will have wide ramifications. Yes, what is it?
May please, Your Lordship, there is some wrong in the translation typography of the claim in the WS, and there is more substance. It is not side.
Whether the title suit is maintainable in view of the provisions contained in Order 9, Rule 9, as the earlier suit being title suit was dismissed for default. In other words, whether for the same cause of action a fresh suit of is maintainable when the earlier one.
Then here I couldn't some of law.
Suit is not maintainable. Why do you need all this? If this is a cause of action, substantial question of, is this a substantial question of law?
What has happened, Your Lordship? The plaintiff has filed the suit on the basis of a expertise judgment decree. The expertise judgment decree on appeal was set aside on merit. The plaintiff has no primary case, and it was remanded back to the trial court. In the trial court, it was dismissed for default. On the basis of that, only on the basis of this judgment and decree, the court has the judgment decree was not even exhibited by the plaintiff. On the basis of the judgment of the judgment decree, they have annexed one this order on the basis and exhibit 4, which is the Jamabati copy. On the basis of the suit was decreed and it was affirmed by the appellate court. And one may I read this question of law, it will be clear.
Which one?
I've been a part.
Substantial question of law. What is it? There is only one substantial question of
Other
law.
there is after
I'm not going to look into all.
because and they have claimed 2 quarters 12 lessons of land. The
No,
Tribe has-
Mr. Gogoi, wait. Look. You filed a suit
I don't follow
with the plaintiff.
they have
The plaintiff filed a suit claiming right title and interest initially.
initially there was an expertise judgment and decree.
We'll go by that.
Yes.
Let us not go down to so much. The plaintiff filed a suit for declaration of right title and interest and declaration of possession or whatever.
Recovery portion of 2 quarters 12 lessons.
That is that. Then the suit proceeded ex parte.
No. Again that order we have filed an appeal.
It is long time. Suit proceeded ex parte against the defendant and a judgment ex parte decree was passed.
No.
Isn't-
The
Wait. Against that you file an appeal. That appeal, appellate court remanded the matter back to the learned trial court for a decision afresh by giving you the liberty to file your written statement. Isn't it? Thereupon, the suit got dismissed. Okay? Then they filed another suit and now got a decree which have been affirmed in the appeal. And
Now the
therefore, you have raised the issue as to as regard Order 9, Rule 9.
Okay.
Isn't it?
Yeah.
Long and short story.
Yes. This is the
and the
Is it on the same cause of action? Is it on the same cause of action or not?
the whole the decree was the different cause of action they said that I have
different cause of action.
vacated.
Different cause of
Different
action.
cause of action.
That is why you must have seen,
Ah.
I asked Mr. S.J. Sharma to look into it. See section 12. There is a bar, but subject to being the same cause of action.
Same cause.
Otherwise, this is not a substantial question.
In the whole suit was on the basis of the judgment of the earlier judgment decree. If your lordship see the judgment findings of on the basis of earlier judgment decree. But earlier judgment decree was set aside by the appellate court. On the basis of the judgment decree, the court has made finding.
I'm asking you a simple question. Is this the same cause of action? Answer that. Matter ends there.
Yes.
Because Order 9, Rule 9 would only apply, or bar is only there only insofar as the same cause of action.
The title document they have given is the Jamamati. In the
Again, you are going to right and left on it. I'm asking a simple question whether it is the same cause of action.
the person is different.
Then, matter ends. No substantial.
Your lordship, the decree was-
Whether for the same cause of action a fresh suit is maintainable. Obviously, the suit is not maintainable. There's no, but can this be the substantial question of law involved in the appeal?
the suit was decreed for 2 quarters 16 lessons. But in the plain, they have asked for only 2 quarters 12 lessons. In the judgment decree, the court has given finding of 2 quarters 16 lessons. But in the schedule, it is 2 quarters 12 lessons.
You want 4 letters more.
The plaintiff has
But Mr. Gogoi, this is not a substantial question of law in the present appeal.
other substantial question law.
Others are not framed. You have to go through a course of Order 41, Rule 11. This court has to be satisfied. And this court is very stingy in formulating questions of law.
Your Lordship, you see the title documents only the Jamamoti, the 1957 and 1958, where our petitioner name is there. They have not exhibited sale deed.
So you are submitting that this is not a substantial question of law, but there is other substantial question. Come to the point to that effect. What is the other substantial question?
On the
So the decree was passed on the basis of revenue entry.
yes, ex parte, the decree was passed.
Again, revenue entry.
Yes, yes. Revenue. At
The document of title is the revenue entry,
yes, yes,
not on the basis of title document.
yes, yes. That PW4 has stated in the cross, our name is there. PW4 is their witness. They stated that our petitioner in interest.
Yes, Mr. Chaudhary, you have not given the document of title.
That part, Lordship, in the issues, it has been taken into account.
Huh?
With regard to the right title interest of the plaintiff, it is there in issue number 3, Lord. Issue number 3, the trial court judgment and decree, where the plaintiff has right title interest over the suit land. Present plaintiff has title over the suit land, exhibit line being the derivant portion of the mutation copy shows in a clear manner that the name of the plaintiff is mutated in tag number such and such, part number such and such. Exhibit 2 and 3 on the other end shows the order of the court delivering the possession of the suit land to the present plaintiff in the year 1981. The exhibits clearly show that the plaintiff has title interest over the suit land. There is no dispute in regard to the fact that possession of the land was conferred to the plaintiff by the court itself earlier in view of the facts involved in the suit, and that of the exhibits. There remains no doubt the plaintiff has a bona fide right over the claim she has made over the suit land as mentioned in the title of the claim. To add further, the plaintiff may very fairly and in a sincere approach claim 1/3 of the share of the total land consisting of 1 bigha 2 kathas 16 leches, which stands at 2 kathas 12 leches of land as mentioned above. The title of the plaintiff is very much explicit over the claims being made on the respective share of land. So that has been clarified in the issue number 3, Lord. The lower appellate court also, while discussing the issue number 3,
You have not, is this your claim? Page 9.
The type copy.
Is there
no,
any
this is not the
mistake in this?
correct
Yes,
type copy. This is
Correct
not the
type
correct type copy.
The type copy I have given.
Subsequently, he has furnished the correct type.
Is this okay?
Yeah, okay. It was filed by from another advocate.
Some typographical mistake. Type.
Do you admit to this particular corrected copy of the claim?
I have earlier. I filed the copy earlier.
Earlier, but not.
It is from, you are for Mr. Sikdar? Oh, Ali. It is Sikdar only. Yes, have you looked into it? If this is a case, what is the plaintiff's case? Your entire case is on the basis of the suit, the
Yes,
decree passed in the suit,
The previous suit.
which suit was already dismissed for default.
No, Lordship, that possession, because what we have stated in the.
Understood. Everything is understood. You see, kindly appreciate that. Your suit was initially filed for declaration of right, title, and interest.
Exactly.
As per the plain, you claimed you got an ex parte decree. You further say that on the basis of the ex parte decree, you were handed over the possession. Thereupon, you continued. In 1996, 96,
90.
they construct trespass into the land and constructed.
The defendant.
Defendant.
Yes.
Now you say that that land has already been decreed in your favor. And as such, now in 2000, why are they trying to dispossess me or have dispossessed me? This is your case.
Recover your possession.
What do you mean?
Yes.
Now, isn't it the requirement that you have to show a document of title? If it was a decree, it would have been different thing. But without a decree, would it be the trial court or the first appellate court have decreed the suit? On the basis of this, see the plain. Therefore, you have a look. I'll have it on some other day, but have a look at the plain. The plain makes it very clear. It is all entirely on the basis thereof. Now, heard Mr. S.R. Gogoi, the learned counsel, appearing on behalf of the petitioner.
The substantial question of law
Mr.
is to be
S.P. Chaudhary.
formulated. Substantial question of law is to be.
I'll
Yes.
get him. I've also heard Mr. S.P. Chaudhary, the learned counsel, appearing on behalf of the response. This court, upon hearing the matter, finds that there is an additional substantial question of law which requires to be formulated in the instant appeal. Whether the learned trial courts below were justified in decreeing the suit in favor of the plaintiff in absence of any document of title admittedly being produced before the learned trial court, before document of title being exhibited in accordance with law. Number two, whether the findings arrived at by the learned trial of the learned trial court that the plaintiff has right, title, and interest over the suit property is suffers from perversity in view of the evidence on record. Taking into account the above, the matter will be listed again on. We'll have it sometime after vacation. After vacation,
Yes, sir.
I think you should go after vacation.
After vacation.
Okay. Listed again on 16th of July, 2024. During the course of hearing, Mr. S.R. Gogoi had submitted a translated copy of the plaint as well as the written statement. This court would, as well as, it is the opinion of this court that these be brought on record by filing an affidavit.
Apply.
In fact, this section 12, nobody reads it. The CPC, nobody reads it. But once, while I was doing a matter, somebody showed me this section 12. And then I said, oh, this is why the question of res judicata or anything is not relevant because of section 12.
Yeah.
If there is a bar in the suit, but you have to understand, it has to be on the same cause.
Same cause of it.
Therefore, his question of law is there, section 12. But if it is
Same
not
cause
on
of-
the same
yes.
cause of action, obviously it is not on the same cause of action because of the. So his first question of law is not there at all.
Now it has been formulated.
Because there it was in 1979 on the basis of whatever may be. But here in the paragraph number 9, it says that in 96 they have taken over possession. 99 they have constructed house, and on 2003 they denied they are not. So this is on section. This
12.
order 9 rule 9 does not come. Anything? Or you are with him?